Hey guys, happy Mother's Day if you're celebrating. We're going to do a hearing prep tomorrow starting at 8:30 in the morning East Coast time. These are Florida cases that we're dealing with. We have a hearing for Alicia Andrews. It's really the first hearing. We were supposed to have sentencing back in December of 2025. And because there was the movement to disqualify Judge Sisco, and Judge Sisco denied that, and then they appealed that decision up to the Florida Second Court of Appeals, who agreed to disqualify Judge Michelle Sisco. And then we had to get the new judge, Kimberly Fernandez, in there. There's just been a lot going on. And with the change of judge, we had some requests for a reconsideration of previous pretrial and trial rulings. So these motions that we're going to look at today have spanned from February through April, and they're going to have their day in court tomorrow to be argued. We're going to do a deep dive on these three things just to get the refresher. But I thought it'd be important if we started off with some of the big questions I see, some of the things I see repeated over and over, and give some clarity here. So refresher on the Alicia Andrews verdict, right? It's been a while. That was October 31st. It was Halloween night when the jury returned their verdict in the Alicia Andrews case. She was not convicted of the top charges. She was facing counts 1 and count 2, the same counts that the other 4 were charged with, although she didn't have the enhancement for the gang, and neither did Sean Gathright. But she was convicted of a lesser. So rather than first-degree premeditated murder or a worse lesser of second-degree murder, she was convicted of manslaughter. And she was acquitted on count 2, which was the conspiracy to commit first-degree murder. In the verbiage of her verdict reading and instructions, there's nothing to do with firearm possession. And the reason that's important is, especially in Florida, we have this 10-20 to life. If you do something with a firearm, it can enhance the classification of what you're convicted of. And when your classification is enhanced, it changes your sentencing timetables. So we don't have that aggravating factor tacked on that she was found to be in possession and or used a firearm. And that would mean she's just facing the basic framework for a manslaughter conviction. So that's a second-degree felony. There is no mandatory minimum. So that would mean that she could get probation for X amount of years. I don't think that's likely, but I'm just saying that's the benefit of not having this firearm enhancement, one of them. And currently, this decision will be in front of the new judge, Kimberly Fernandez, which was a big point of the defense team. They were concerned, and Alicia Andrews was concerned, and they had to state this in their motion, that she was afraid she wouldn't have a fair proceeding if Judge Sisco continued to preside over the sentencing stage. And that's an issue you have to raise verbally as part of these types of motions. And then if this is denied again, she's facing that maximum of 15 years. And if there's no relief granted for these other motions, no new trial, and we proceed to sentencing, what I think we'll see argued, her team's going to argue, look, she was an accomplice. She didn't know. We could say she knew less than the others. Maybe she was afraid to try to stop and say something because of this possible DV history. And the state's going to argue, well, the nature of the crime was extremely violent. She was there. She didn't say anything after. And while sentencing isn't supposed to take into consideration the acquitted crimes, because she was still convicted of something relating to the shooting, they will be able to consider the violent nature of what happened to Charles Jones and the 3 other victims that fortunately did not lose their lives. So bottom line, if it goes to sentencing, they're going to have to do some arguments. They're going to want to do a pre-sentencing investigation, which looks at, is there any criminal background, any probation issues, which I think the only prior issue Alicia has is like resisting arrest, and it's in relation to this. And there's no conviction for that. She was just charged and arrested with it. So I don't think there's going to be anything on her background. But a probation officer could give some type of recommendation like, hey, we think she could be rehabilitated and maybe don't go for the maximum. Or we have these concerns. Here's what they are. And the judge could take that into consideration. If the judge goes above or beyond the recommended ranges, that would either be an upward departure or a downward departure. and they typically have to give a reason for doing so. And if they don't give a reason for doing so, it's probably going to be appealed. So that wraps up a little bit on the sentencing background. That was a big question a while ago. And I think the last thing worth clarifying, and this has its own slide, you guys. This one has its own slide. If Alicia Andrews is granted a new trial, she gets a do-over. I've seen a lot of comments, oh, she'd be stupid to do that. She doesn't have anything to lose, really. I mean, I don't think she's coming out of pocket to pay for her. She has indigency status. So it's not like she's running out of funds. You know, she has funds through the court. And she could only be retried on what she was convicted for or something that would be a lesser of those things. You cannot be retried on something that a jury has acquitted you on. So it's not like she could go back to this trial and suddenly get convicted of first-degree murder, right? Her biggest risk would be getting convicted of manslaughter once again. And they can't retry her on the conspiracy count, which I think is quite interesting because, you know, maybe that conspiracy count allowed them to introduce certain elements that aren't relevant now if they can only retry her on manslaughter. So, I don't know. I think it'd be an interesting round 2, and I would certainly be interested in watching that play out if that's what happens. So, there is no, like, oh, she better just cut her losses. Why would she fight that? She got a blessing. Like, it can't get any worse than it is. And if she were to be sentenced to something like 10 to 15 years, it's not like she'd be wasting her time with a retrial. She's in custody anyway. So that kind of wraps that up. Those are the housekeeping, the quick tidbits there. And scheduling, guys, again, tomorrow at 8:30 for Alicia Andrews, but remember, we'll have the penalty phase starting for the Fulio 4 that were convicted on Friday. Whether or not the jury will decide to recommend the death penalty for those 4, that proceeding will start at 1 p.m. So it's going to be Alicia Andrews' hearing in the morning, and then in the afternoon, they're going to kick off that penalty phase. So we'll be watching both of those here if you want to watch with us. And then one other thing before we get into the motions. I wanted to read to you the verbiage that Sisco read for the manslaughter instructions. And the reason I want to do this is I've seen people say, well, the jury found that she intentionally did something that caused the death, because that is some of the verbiage. But there's an or here. So it's not clear what the jury actually decided, and it's possible that different jurors felt differently and had a different pathway to reaching the same verdict. So let's read the language here. So she said, I'm going to tell you about manslaughter lesser to count 1. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, that Charles Jones is dead. And nobody was disputing that, right? Everybody agreed that Charles Jones was the victim in this case. 2, and this is the important part, there's going to be an A and a B to this part 2. So part 2, one way, is that Alicia Andrews, you find that she intentionally committed an act or acts that caused the death of the victim. It's one way. But 2, or B, the death of the victim was caused by culpable negligence of Alicia Andrews. Now, these are 2 different things. One is I intentionally did something that caused the death of the victim. That could be like if I'm driving through a parking lot and I slam on my accelerator. I am intending to peel off, and in the process, I end up running someone over. So my intent wasn't to run this person over, but my intent was to slam on this on this accelerator and get up out of there, and in the process, I did something. Well, that act's intentional. So that's kind of one way we could get to this. This B option, though, the death of the victim was caused by the culpable negligence of Alicia Andrews. So it's not requiring her to take a positive action, to actually do something. It could just be because she was negligent and did not do something. So let's read this a little bit more. Every person has to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide. As I've previously instructed you, in order to convict of manslaughter by act, It is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable and which caused death. So this element here, and I should have put a paragraph here, is like the part A. That would get us to this part. Then Michelle Sisco says, I will now define culpable negligence for you. That's that other option, part B. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons, exposed to its dangerous effects of such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct. Oops, I guess I should have gotten another line here. But you see how there's these two different pathways that aren't exactly the same. So, and we don't know exactly what the jury, maybe all 12 of them all think it was part A, maybe all 12 of them all think it was part B, maybe it was a mix. But there's no way to tell based on the jury verdict. And I'm not aware of any juror interviews that shared their own insight for the Alicia Andrews trial. It's unclear if they think that she intentionally committed some act that led to the death, or if they think she was just grossly negligent by not doing something to stop it or saying something in the time that it was happening, right? So it's a little bit of a gray area based on the way this is worded. So there's that. That rounds us up to the first set of motions. And again, so the way this works is if a party raises a motion, and here it's going to be the defense team, it's going to be Alicia Andrews' team raising a motion. The opposing party, the state, the prosecution in this, has a chance to respond, and then in opposition. And then the original moving party, the defense in this case, gets the final reply. So when you're the moving party, unless there's permission to keep going back and forth and do something that's called a surreply, S-U-R, it's typically moving party, a reply, and then a final rebuttal to that. So, and we kind of see the same thing with closing arguments, right? The party who has the burden of proof, they get an opening closing, then the opposite party gets their closing argument, and then we get a rebuttal closing. So there's going to be 3 filings here: defense, then the state, and then the defense's final reply. So we're going to do a deep dive through these motions. And one other thing I thought would be interesting to go through, if you guys are interested in hanging out a little longer today, is a pretrial hearing from August of 2025, where the issue of the inclusion of domestic violence was argued. So we have that on the table. And we're not going to rewatch the trial, but we did just rewatch some highlights during Verdict Watch on Friday. And there's the whole playlist of the Alicia Andrews trial in the description if you want to really go back and watch the whole trial. So let's get into this. Let's get you guys on the screen here. Hey, chat. How you guys doing? How you guys doing? Oh, no. Oh, Bailey's is in YouTube jail. That's Factual Lie, you guys. Factual Lie is over on the Twitch island today. I don't know if you're a mom, Factual Lie. If you're a mom, happy Mother's Day. Oh, sorry you're stranded over there. We'll get you on the screen here, though, with us. All right, so this is February 22nd. This is the defendant's motion, Alicia Andrews' motion to reconsider previous pretrial and trial rulings. And when you do a motion to reconsider, it's a bit self-explanatory, but just in case you've never thought about it before, a ruling and order has already come down. And we're asking you to, think about that again and maybe change your mind, right? We don't like your decision. We want you to, would you reconsider and change it? Think of in YSL, the state asking Judge Whitaker to change her ruling on the forfeiture stuff. So they wanted a reconsideration of previous rulings and second amended motion for judgment of acquittal, notwithstanding the verdict. So this means even though there's a jury verdict, you as the judge were asking you as a matter of law or something was so fundamentally wrong with this case that we're asking you that despite the verdict, we want you to acquit our client, the defendant, of what she was convicted of, and or a different type of relief, a motion for a new trial. Now, there's a footnote here that I never saw come through the docket. The footnote said that Ms. Andrews intends to submit supplemental briefing on her request for the court to reconsider her motions for judgment of acquittal made during trial. So I didn't see a supplemental brief come in. It looked like they might have had a short hearing one day. Maybe they discussed this then. I don't know. But I just never saw it pop up on the docket. So here we go, you guys. Alicia Andrews, by and through undersigned counsel, respectfully moves this court to acquit Ms. Andrews, notwithstanding the verdict rendered in her trial, or in the alternative, grant Ms. Andrews a new trial and in support thereof states as follows. So this is their version of what happened. The 2nd District Court of Appeal, having found Ms. Andrews' motion to qualify the trial judge legally sufficient, and Judge Michelle Sisco being disqualified from these proceedings, allows this court to reconsider each of the previous judge's factual and legal rulings. These rulings include, but are not limited to, rulings and motions in limine, motions for judgment of acquittal, motions for special jury instructions, and all rulings on the evidentiary objections made during trial. So that's why it's pretrial and during trial. The prior rulings may be reconsidered and vacated or amended by the court. Ms. Andrews requests the court reconsider her motions for judgment of acquittal, vacate the previous denial of those motions, and grant Ms. Andrews' motion for judgment of acquittal. In the alternative, Ms. Andrews requests a new trial because the only remedy for the remaining rulings, supra, would be to impanel a new jury so that the case may be tried with the correct pretrial and trial rulings. Under the circumstances, Ms. Andrews is due a new trial. At the very least, this court or the appellate court must grant Ms. Andrews a new trial because the disqualified judge committed reversible error by denying Ms. Andrews' legally sufficient disqualification motion. The error was not harmless because the judge made several consequential decisions that could have altered the outcome of the trial. So they're challenging the confidence we can have in the verdict based on, these rulings. Had the rulings gone in the opposite direction, they strongly believe that the trial outcome would be different. That's what they're arguing. Namely, the previous judge denied Ms. Andrews' motion for special jury instructions. For this ruling alone, and the others collectively, the previous error cannot survive a harmless error analysis. Thus, a new trial must be granted. For the sake of judicial economy and efficiency to the parties, this court should grant Ms. Andrews a new trial rather than passing the issue to the appellate court, who will surely grant Ms. Andrews the requested relief. So they're hinting that they're so confident in these arguments that you might as well do the job here. So right now, this is still in front. This isn't technically an appeal. This is like post-conviction, pre-sentencing motions for relief. They're requesting the trial court, although we've had a switch of judge, it's still at the trial court to grant this relief. If this relief is not granted, then they would appeal. That would be the appeal stage. So their facts of the case. They say on June 23rd, 2024, the victims in this case, Charles Julio Jones, was killed by masked gunmen. Within months, Ms. Andrews was arrested for Mr. Jones' murder and subsequently indicted as a principal to 2 criminal acts. So count 1 was the first-degree premeditated murder, and count 2 was conspiracy to commit first-degree premeditated murder. Ms. Andrews had 4 co-defendants, all men, all arrested and indicted for the same or similar charges. So now they're going to break it into sections. They're going to talk about the motions in limine. So prior to the start of trial, the defense moved in limine to preclude the state from introducing evidence of a years-long Jacksonville gang war, rap music videos, and various uncharged crimes the state sought to introduce. Now, again, we're analyzing this in the lens of this case. They're all indicted together, but Alicia Andrews was tried separately. I see there's a lot of conversation that is because she requested a speedy trial. I think that's in part why they had to move her along so quickly, but there are motions on the docket where it stated that the reason for her severance was the state was not seeking the death penalty against Alicia Andrews. So, to me, that's a pretty strong reason also to sever co-defendants. So she had these motions in limine, and again, in her part of the indictment, similar to Sean Gathright, Alicia Andrews and Sean Gathright, they were not, in the indictment, there's no language including their names for the gang enhancement, that what they did was in furtherance of a gang activity. So just keep that in mind. So the idea that if she's being tried on her own, maybe you have a stronger case to make to exclude all of this evidence about the back and forth gang war. because it doesn't really go to her state of mind necessarily. So Judge Sisco ends up denying that defense motion and allowed the state to introduce the evidence. The defense also requested that Ms. Andrews be allowed to present evidence about the nature of her abusive relationship with co-defendant Isaiah Chance, and that's the hearing that we're going to watch at the end of the stream. The defense proffered that such evidence was relevant to Ms. Andrews' state of mind, which is always relevant in a first-degree murder case, where the state has to prove intent and premeditation. Although the defense made it clear that it was not introducing this evidence to support an affirmative defense to murder. And this, I agree. I think they made this clear, and I want to know your thoughts when we watch this hearing. I agree that they made this distinction clear and had to repeat it. But Judge Sisco, just her response and her reasons in her ruling, it seemed like her finding was based on, you can't use that as an affirmative defense unless your client takes a stand. Even though the reason for bringing it in was not to take the affirmative. That, yes, I committed this first-degree murder as charged, but I did it because I was under duress in the moment. And I do think the defense made a distinct argument, and the judge just didn't pick up on it. So I'm interested to see if this judge or the appeals court weighs in on this issue. So anyway, when defense was trying to make this motion, Judge Sisco and the state erroneously and repeatedly framed the defense request as an attempt to use domestic violence as a vehicle for a duress defense. Initially, Judge Sisco ruled that such evidence was inadmissible. Judge Sisco would later change her ruling on the first day of trial, infra, but never allowed the defense to fully introduce the extent of the domestic violence exhibited towards Miss Andrews. Now the stories presented at trial. Next category. So at trial, the state attempted to prove that Miss Andrews conspired with her co-defendants to kill Charles Jones. Why? What was their theory? The state's theory was because Mr. Jones, an alleged gang member, was engaged in an alleged gang war with Miss Andrews' co-defendants, who were allegedly rival gang members or gang associates. And this is why the state had argued to be able to bring all this gang information in, because it was indirectly related to Alicia's involvement. Over the years, many children, teenagers, and young adults were killed as a result of this gang war. Astonishingly, the state's witnesses admitted that Miss Andrews was not a gang member nor a gang associate. Neither was Miss Andrews involved in the Jacksonville gang war. According to the state, Miss Andrews' co-defendants wanted Mr. Jones dead for personal vendettas that they had with him. However, that's that text message from, what was it, like 2021 or something? He need to die. That's me quoting an exhibit, YouTube, just in case YouTube's listening to me. However, the state argued that Miss Andrews joined the conspiracy solely because of an underlying allegiance to her then-boyfriend, Isaiah Chance, the co-defendant. According to the state, the Jacksonville gang war spilled into Tampa, Florida, when Miss Andrews traveled from Jacksonville to Tampa with her co-defendants to stalk and kill Mr. Jones, who was present in Tampa to celebrate his birthday. Miss Andrews was allegedly a lookout or a spotter for the group of boys. The defense, and being a spot out, if the jury believed, or some jurors believed, because again, they could have different ways to get to the manslaughter conviction. Some jurors could have believed, based on what's contained in the instructions for the manslaughter, that she was a lookout, because that's an action that could lead to somebody getting spotted, and it might not necessarily be an action that means she wanted him to get taken out by these assault rifles. Maybe she thought they were just going to jump him and not kill him. I don't know. But they could have thought maybe that's what she thought. The defense denied the state's allegations, arguing that Miss Andrews never conspired with her co-defendants to kill Mr. Jones. Miss Andrews did not even know two of her co-defendants. She never had a conversation with them, much less an opportunity to develop a murder plot. The only co-defendant Miss Andrews had a relationship and any communication with was her then-boyfriend, Mr. Chance. When Miss Andrews discovered that Mr. Chance was leaving Jacksonville to go to Tampa, Miss Andrews wanted to go with him. Miss Andrews knew nothing about a murder plot when she decided to make the trip. And I think even though I'm sure there was a lesser for the conspiracy, I think the acquittal on the conspiracy suggests that the jury did not believe or did not think the state proved that Alicia Andrews had done this type of plotting. So She merely believed she was going out of town to spend time with Mr. Chance. Mr. Chance and the other co-defendants arrived in Tampa, left Miss Andrews at an Airbnb for hours, and went to look for Mr. Jones. At first, the group of boys were unsuccessful, but they continued their efforts and eventually were able to locate and gun down Mr. Jones. Miss Andrews provided no identifiable assistance. Several times throughout the night, Mr. Chance manipulated Miss Andrews and used her phone to conceal his whereabouts. Miss Jones did not know about the conspiracy, thus she lacked the requisite intent to be a principal to first-degree murder and conspiracy to commit first-degree murder. And the jury seems to agree with this part. Preview of the trial issues. As the trial progressed, several evidentiary issues arose. In addition to the evidentiary issues, the court considered motions for judgment of acquittal, which were ultimately denied. The court also ruled on the defense motion for special jury instructions and the motion to disqualify Judge Sisco. And so again, this is all referring to Judge Sisco weighing in on these requests, even her own disqualification. Below is a recitation of these issues that were ruled upon by the court during trial. So first up, we have evidence of co-defendants' abuse towards Miss Andrews. The state attributed Miss Andrews' love, and that's in quotes, for Mr. Chance as the reason for involvement in the murder plot. The state presented Miss Andrews as a young woman who was madly in love with Mr. Chance. Was it Juan Ramos that was like they were lovers? And who would do anything for him? In reality, Miss Andrews had no motive for wanting Mr. Jones dead, and her relationship with Mr. Chance was not as the state presented. The defense sought to establish the true nature of their relationship between Miss Andrews and Mr. Chance. Mr. Chance consistently abused Miss Andrews through the acts of violence, intimidation, and manipulation. The defense sought to present specific incidents of this violence and influence to illustrate Miss Andrews' state of mind during the relevant conspiratorial acts and time periods. Just prior to opening statements on October 22, 2025, Judge Sisco announced to the parties that the court would allow the defense to present the evidence of domestic violence, but the court limited the evidence to only come in through Miss Andrews' testimony. And now, what impact did this have? So, ultimately, any trial you watch, it's always the defendant's opportunity to decide if they want to take the stand in their own defense or not. If they don't, the jury is going to be instructed that they should not hold that against the defendant for choosing not to testify. But, that moment where a defendant is finally asked, all right, are you going to waive your right to testify? Do you want to testify? Are you doing this knowingly? Did your lawyer pressure you or threaten you to make this decision? There's so many things that can happen at trial where it can be a whirlwind of making this decision. But if you have to go into trial, one, thinking that this is off the table completely, and then finding out, well, it's kind of a little bit on the table, but only if Miss Andrews testifies, that's a pretty significant impact to what you might be considering in your trial strategy right on the morning trial's about to start. You're about to do your opening statements, and now you might have a major reason to shift your trial plan. So, notwithstanding Judge Sisco's ruling that the domestic violence could only come in through Miss Andrews, the defense attempted to call defense witnesses who could speak to their personal knowledge on the domestic violence relationship between Mr. Chance and Miss Andrews. Defense counsel argued that Miss Andrews' witnesses should be allowed to testify for two primary reasons. First, to rebut the state's argument that Miss Andrews was not afraid of Mr. Chance. Second, because the evidence was relevant, and the court had no basis to limit relevant evidence to Miss Andrews' testimony. Judge Sisco ruled that testimony from Alicia's friends about the abuse they witnessed was irrelevant because the friends did not know what Miss Andrews' state of mind was on the day of the shooting. Then they go into years-old text messages. During the trial, the state sought to admit text messages between Alicia Andrews and her childhood friend, Jewel Jordan, from 2021. Yeah, this is the he need to die. 3 years prior to the homicide. Among other things, these messages showed the two girls discussing Mr. Jones, who was a well-known musician. And they're adding this bit here because they could be discussing him like people stands on Twitter fight over Tyla versus Rihanna, right? Include that little tidbit for that reason. In the text messages, the two girls showed disdain for Mr. Jones. Miss Jones texted Miss Jordan that she did not like Mr. Jones, Fulio, that Mr. Jones was an ugly-ass bee, and that Mr. Jones needed to die. The defense objected to the admission of these text messages. I should get my little disclaimer here because YouTube hates me. This is the court feed. Court things. The defense argued that the text messages occurred long before the conspiratorial time period, and that they had nothing to do with the homicide conspiracy at all, making the text messages irrelevant and prejudicial. Judge Sisco believed that the text messages were relevant to show that Miss Andrews knew about Mr. Jones and the gang violence surrounding him. The defense argued that Miss Andrews' knowledge of Mr. Jones was established already, and that it was nevertheless overly prejudicial to admit the text messages, which had nothing to do with the present plot to kill Mr. Jones. Judge Sisco allowed the state to admit the text messages, ruling that the messages were so probative that it outweighed any prejudicial impact. Next is the charge conference. So this is going to be the language that goes into jury instructions, where the parties request certain paragraphs or special instructions to add or remove from what would be like a template model instruction relevant to the charges at play. So during the charge conference, Judge Sisco and the parties addressed the lesser included offense of manslaughter. Judge Sisco asked the defense whether it was seeking the manslaughter instruction under both the intentional act and culpable negligence theories. The defense requested that the jury only be instructed on the intentional act theory. So you see how that either or branch, comes into play here a little bit. The defense requested that the jury only be instructed on the intentional act theory because that's what the state was presenting. The state said everything was intentional. That was the theory. That was how they approached the case. The defense requested that the jury only be instructed on the intentional act theory. Judge Sisco then asked the state if it wanted to include the culpable negligence theory with the manslaughter instruction. The state responded yes. Judge Sisco included the culpable negligence theory in the manslaughter instruction over the defense's objection. Subsequently, and personally, I think this might be one of the bigger issues. Maybe not what a case could be overturned on. But I do think if this conviction's vacated, the state's going to have to decide how to present this case. And if they can only try on manslaughter under this A or B theory, when they argued that she was like a full participant, conspired, and all of this other stuff, their case would look so different in a retrial. So subsequently, the defense requested the following special jury instructions be included in the principal theory instruction. They wanted a mere presence instruction. And listen to this. Mere presence at the scene, including driving the perpetrator to and from the scene, is not sufficient to prove that the defendant intended to commit a crime. Now, mere presence is something that there's model instructions for a mere presence instruction. It's not unusual to include. There's like examples of how to pre-write it so you can just insert it and bloop it in. Do you think this instruction's relevant here? Because we're going to find out it was denied. But it seems like it's, if the jury's, we don't know exactly how they got to this manslaughter. But maybe if they are weighing, well, she was there. If we don't include mere presence, maybe including that instruction could have led to a different outcome. So that's one of the things that they're arguing, that the exclusion of this request was problematic. Next, they say a display of questionable behavior after the fact is not sufficient to prove that the defendant intended to commit the crime. Next, they say knowledge of the crime after it was committed is not sufficient to prove a conscious intent of the crime. And I don't know if they really needed this because, again, they could have, we don't know. We can't get into the jury's mind. They could have still convicted on this, even if this was instructed. So then the state argued that the standard jury instruction was sufficient. The defense argued that Miss Andrews was entitled to the instruction because 1, the special instruction was supported by the evidence, 2, the standard instruction did not adequately cover the theory of defense, and 3, the special instruction was a correct statement of the law. The defense cautioned Judge Sisco that if the court refused to give the special instructions, the case would be reversed on appeal. Do you remember this part, guys? Let me know if you remember this. Judge Sisco disagreed and stated that if there was a conviction, the Second District Court of Appeal would tell her otherwise. I remember that. Judge Sisco did not provide a basis for her denial of the defense's request for the special instructions. So we've got the motion to disqualify the judge. On October 31st, after the charge conference, the defense filed its motion to disqualify Judge Sisco. The motion was based on various instances of clear bias. Judge Sisco reviewed the motion in chambers and eventually denied the motion as being legally insufficient. So we've got the verdict. The verdict. The case was handed to the jury on October 31st, 2026. After deliberating, the jury found Ms. Andrews guilty of the lesser included offense of manslaughter and not guilty of conspiracy to commit first-degree murder. And manslaughter is always abbreviated here, but there is a first and second degree of manslaughter. But first-degree manslaughter is like, I forget the elderly range, if it's like 55 plus or 65 plus or what the age is, and under 18. So it's there if you commit manslaughter against a protected person. So an elderly person, a child, an officer. Really everything else is just standard manslaughter, which is technically classified as second-degree manslaughter. That's why they write it in plain language. So they find her guilty of the lesser included of manslaughter and not guilty of conspiracy to commit first-degree murder. In essence, so this is reading into what this means, the Alicia Andrews team is saying that the jury found Ms. Andrews not guilty of first-degree murder and second-degree murder, the higher offenses. The jury's verdict indicates that the state failed to prove that Ms. Andrews acted with any criminal intent that the homicide occur. So again, specifically to the act of homicide, right? We can't rule out that the jury felt that she intentionally was fine being a lookout in that moment at the hotel, but didn't really conspire beforehand or anything. But the intent to commit a homicide is off the table, according to the acquittals, as is required to convict under the principal theory. The verdict is questionable because there was absolutely no evidence of a manslaughter introduced in the trial, which again, this is why they were, requesting only one theory of the manslaughter instruction to be included, because there was no evidence of just culpable negligence being the cause. So, and again, I'm interested to see how that's weighed in. I mean, I love appeals, you guys, and I just feel like that's the type of issue, jury instructions, what goes back, saying something that you shouldn't have included over defense objection, or not including something even though the defense requested it. Often that's like the appeals that I read, the jury instructions become the reason the appeals court is like, yeah, this was a problem. Like, I just think courts of appeals really like to nitty gritty on jury instruction issues as opposed to other things, Oh, ineffective assistance of counsel. Oh, well, it wasn't significant. It didn't impact anything, even if it happened. The judge made a bad ruling during trial. It didn't impact the outcome. It's fine. It was harmless. But jury instructions seem to be more often than some other issues the type of thing that Court of Appeals fixates on. So I'm anchored in that issue out of all of these, if any. All right, so we've got now, let's see, post-trial. What happened post-trial? We've got, after the trial, the court set Ms. Andrews' sentencing hearing for December 8th, 2025. Yeah, that's how long ago. That's a long time ago. On November 11th, 2025, Ms. Andrews filed a timely motion for judgment of acquittal notwithstanding the verdict and/or a motion for a new trial. On December 4th, 2025, Ms. Andrews filed her writ of prohibition, and that's then she's going up to the Court of Appeals with the Second District Court of Appeal, challenging Judge Sisco's denial of the defense disqualification motion filed on October 31st, 2025. And the rationale behind this is, we want the Court of Appeal to evaluate this decision because at the initial stage, when you file a motion to disqualify the judge, it's that same judge weighing in on their own disqualification. So it's asking Judge Sisco herself to say, yeah, you sufficiently alleged, and you just have to make a prima facie showing where, unless there's something to contradict it, looking at it in the light at a first glance, it's a sufficient allegation that Miss Andrews has reason to fear that I wouldn't be impartial. So she denies that. That's why they got to file this writ of prohibition to challenge her own denial of a motion to disqualify herself. On December 5th, 2025, the Second District Court of Appeal issued a stay in the trial court. So you can't proceed with the sentencing until we make a decision on this outstanding issue. On January 27th, 2026, the Second District Court of Appeal issued its order granting Ms. Andrews' writ of prohibition and removing Judge Sisco from Ms. Andrews' case. Now it's Judge Kimberly Fernandez. Ms. Andrews files this motion for reconsideration timely. So this series of events, this disqualification, because this came in on February 26th? So it was like 29 days after this change. So they did it within their 30 days. Memorandum of law. Let me get a drink here. Let's see. We've got Rule 3.380C. This is what gives somebody the pathway to request a motion for judgment of acquittal. So under this bit, a defendant may renew a motion for judgment of acquittal after a jury returns verdict of guilty or is discharged without having returned a verdict. The rule provides that such motion must be filed within 10 days after the receipt of the verdict or within such additional time as the court may allow. This procedural mechanism allows a defendant to challenge the sufficiency of the evidence, ensuring that a conviction is entered only when legally supported. Next, we've got Rule 3.580. The court may grant a new trial. So under this rule, when a verdict has been rendered against the defendant or the defendant has been found guilty by the court may, either on motion of the defendant or on its own motion, grant a new trial or arrest judgment. This rule empowers the court to address verdicts or findings that may be legally or factually flawed and to ensure the interests of justice are protected. And then we've got grounds for a new trial. So they're raising these three. They might seem overlapping, but they are three distinct pathways. So 3.600, a court shall grant a new trial when certain specific grounds are established. And this is a shall. It's not a may. Under subdivision A, a new trial must be granted if the jurors decided the verdict by lot. If the verdict is contrary to law or the weight of the evidence, if the verdict is contrary to the law or weight of the evidence, or if new and material evidence is discovered that with reasonable diligence could not have been found and which would likely have changed the outcome. Subdivision B provides additional grounds where the moving party must show that a substantial right of the defendant was prejudiced, including when the defendant was absent from required proceedings, the jury received any evidence out of court other than that resulting from an authorized view of the premises. The jurors so this would be like, they always instruct don't go on social media, don't drive down to the scene and explore it yourself, don't go try to research where this happened. If the juror goes and takes a field trip to look at the scene of the crime on their own, that's an unauthorized view of the premises. And after retiring to deliberate upon the verdict, separated without leave of court, juror misconduct occurred. Prosecutorial misconduct occurred. The court erred in the decision of any matter of law arising during the course of the trial. The court erroneously instructed the jury on a matter of law or refused to give a proper instruction requested by the defendant. So this one we're probably going to see them argue. This one. Or for any other cause not due to the defendant's fault. The defendant did not receive a fair and impartial trial. And then finally, subdivision C allows the court, in ruling on a motion for a new trial that presents factual issues, to consider evidence on the motion by affidavit or otherwise. Then we've got what's the effect of granting a new trial. When a new trial is granted, this is under Rule 3.640, the judgment or verdict previously entered is set aside, and the case proceeds as if the former trial had not occurred, except that when an offense is divided into degrees or the charge includes a lesser offense, and the defendant has been found guilty of a lesser degree or lesser included offense. This is important. We're going to underscore this again. This is our big slide with the red text. The defendant cannot thereafter be prosecuted for a higher degree of the same offense or for a higher offense than that of which the defendant was convicted. So it's manslaughter or less. So it can't happen. It's just not even a possibility. It's not even a possibility here, Chiba. There's no vehicle for this. I mean, if she were to go get free and commit a separate crime and go on trial for that, I mean, maybe. But there's absolutely zero way where she could get a life sentence for something in relation to this indictment. So it would be double jeopardy. She was already acquitted. The only way that an acquittal I shouldn't say the only, but like the very rare circumstance where an acquittal, someone could be retried on something they were acquitted of, is if there's like a bribed juror or a bribed judge. And the theory behind that is the defendant was never in jeopardy. Jeopardy never attached if the judge was never going to convict if it was a bench trial because they were paid off, or 12 jurors weren't going to convict because one or more jurors was paid off, right? They'll say that jeopardy never attached, and then thus double jeopardy doesn't apply. But other than that, and nobody's alleging that in this case, you know, it would be double jeopardy. So, and again, since she is facing like up to 15 years, unless, unless this judge is going to sentence her on like just probation, I mean, really the biggest thing that she would be risking is if her sentence was going to get her out of custody right away whenever sentencing happens, but she chooses to do a new trial. She could fight for bond, but it could be denied. I don't know if it would be denied with just a manslaughter charge, but she could be risking facing longer in custody, or maybe something would happen at this trial where this judge would decide to sentence her more to the max. And I can only speculate, but I do feel like Judge Sisco would lean towards the max if this sentencing was still in front of Sisco. So just because I feel like she was already risking the max under Sisco, not much to lose, if that makes sense. Not much to lose. Hold on, I see was handed on October 2026. Yeah, and that's true. So Rockstar, again, so at the beginning of the stream, one of the reasons I emphasized, where was it? Here. So on this slide, I wanted to put this bit that there's no firearm enhancement as part of how her verdict was read, how her slip was read. Whereas when we heard with Isaiah Chance, we know that the state's theory is Isaiah Chance was not one of the shooters, but they still asked the jury to make a determination with two separate sets of questions, whether or not he possessed, used firearms, and also whether he was actually in possession of a firearm. And he got yes to both of those. And it might seem trivial because if he's convicted of first-degree murder, he's facing life regardless. But that type of enhancement where, let's say he was convicted of a second degree or manslaughter where he's not automatically facing life, that type of enhancement, had they asked those questions involving Alicia and they said, yes, we do find that she possessed a firearm, that's an enhancement that would now take away these no minimums. But they didn't have that for Alicia Andrews. But had it been there, she might not be eligible just for probation. But because there's no enhancements of her, there's no firearm enhancement, there's no gang enhancement, she is, there is a minimum on the table available to her where technically the sentence could just be probation. So a very, very important, or interesting maybe is a better word, distinction between how she was charged and how the verdict was returned and what the jury was asked to consider for Alicia Andrews versus the other defendants. Where were we? We were here. Okay, so now they're going to get into their argument. They laid out some bits and pieces. They've got the verdict is contrary to law or the weight of the evidence. And unfortunately, Chiba, even though this might be an opinion, it's acquitted conduct at this point. So the judge could still find that what happened was very violent and consider the violent nature of whatever she didn't stop, based under her conviction under the manslaughter count, the lesser. They could take that into consideration and say, well, let's bump that up towards a higher end of the sentencing range. But really, this judge is not supposed to take into consideration something that was acquitted. And she was acquitted of conspiracy. So whether that's disappointing or not to some, the judge simply shouldn't consider that. And I really would encourage, even if you want that to apply to Alicia Andrews, imagine if it wasn't Alicia Andrews. Imagine if it was a different case where you had a different opinion on the evidence presented or a different theory on what actually went down that day and leading up to it. We don't want... There's real danger in judges going rogue and considering acquitted conduct for the purpose of sentencing. You know, it's not something that I think we want to promote, even if we want it to happen for someone we might not like in one particular case. But we've got here the verdict is contrary to law or the weight of the evidence. So what is the defense arguing here? A new trial is warranted where the verdict is against the manifest weight of the evidence or contrary to applicable law. Here, the jury's decision to acquit Miss Andrews of first-degree murder, conspiracy to commit first-degree murder, and second-degree murder made it evident that the state failed to prove that Miss Andrews either intended for the crime to occur or that she did some act or said something that was intended to, and that did incite, cause, encourage, assist, or advise the other persons to actually commit the crime. If either of the two principal elements are missing, the jury could not find that Miss Andrews committed manslaughter as a principal. However, the jury incorrectly rendered a verdict that was contrary to the law and the weight of the evidence. And here they quote here some case law. This is Geibel v. State. It's a 2nd District Court of Appeals, so it's the same district that this court's in. In deciding a motion for a new trial pursuant to Rule 3.600b, on the ground that the verdict is contrary to the weight of the evidence, the trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. So, Miss Andrews did not act as a principal to a manslaughter. Charles Jones was not killed by a negligent act. There is no adequate evidence in the trial record to show that Miss Andrews caused the death of Mr. Jones by some culpably negligent act. The state's theory was that Miss Andrews was a fully informed participant in the intentional and well-planned murder of Charles Jones. Now, let's highlight the distinction here. The argument is not that this couldn't have happened by a culpably negligent act. They're arguing that the state didn't present evidence that Alicia Andrews committed manslaughter just through a culpably negligent act, because they did the opposite. They presented everything as evidence of a plot and intent, and that's a sufficiency issue. The weight of the evidence isn't there because they didn't present under that theory. So, nothing about the state's presentation of evidence suggested Miss Andrews' acts were the product of negligence. Thus, the jury's decision to convict Miss Andrews of manslaughter is contrary to the weight of the evidence. Notwithstanding the jury's verdict, the court should acquit Miss Andrews of the manslaughter charge she was convicted of. Next, they say the court erred on rulings on matters of law, including refusal to give proper defense instructions. It's well established that a defendant is entitled to have the jury instructed on the law applicable to their theory of defense, where there is evidence introduced thereof. And so they cite here Motley v. State and Bryant v. State. The Florida Supreme Court has articulated a 3-part test for a special and jury instruction. So if we request a special instruction, like the 3 examples we read above, what's the process to make a decision on whether to include them or not? So first, it's required that the special instruction must be supported by the evidence. Next, the standard instruction does not adequately cover the theory of defense. And 3, the special instructions must be a correct statement of the law and not misleading or confusing. And they cite here Stevens v. State. Then we've got Wright v. State. The court held that a defendant is entitled to a jury instruction on his theory of the case if there's any evidence to support it, no matter how flimsy that evidence might be. And that's from a sister district, the Florida 4th District. Here, the defense requested the following special instruction be added to the principal jury instruction. This one, guys, the mere presence. Mere presence at the scene, including driving the perpetrator to and from the scene, is not sufficient to prove that the defendant intended to commit a crime. Then, a display of questionable behavior after the fact is not sufficient to prove that the defendant intended to commit the crime. And then, a knowledge of the crime after it was committed is not sufficient to prove a conscious intent of the crime. These instructions satisfied the Stevens criteria because they were supported by the evidence in... Okay, this is worded weird. They're supported by the evidence in the introduced at trial. I think it's just supposed to say introduced at trial. The standard instruction did not adequately cover the defense's theory, and the special instructions were a correct statement of the law and not misleading or confusing. First, the state's evidence. And this is a pretty big example, but an example I always think of with jury instructions that get overturned. There was recently an Ohio case that was overturned. I think it was Ohio. It's a state that doesn't have a duty to retreat, is where it was. Maybe it wasn't Ohio. But the defense requested a duty to retreat or no duty to retreat instruction. It wasn't given. The jury convicted, and the conviction was overturned because of that error. The failure to include language that there's no duty to retreat. So, that's the type of thing. I'm telling you, like, jury instructions, like, appeals courts just are like, oh, we love a good jury instruction issue. So, there's a similar example of the exclusion of a requested instruction becoming an issue on appeal. So they say here that first, the state's evidence showed that Miss Andrews was merely present at the scene and that she was in her co-defendant's vehicle during the night of the homicide. Thus, there was substantial evidence showing that Miss Andrews was merely present at the scene of the crime and the first prong was met. And it doesn't mean that this is the only possibility of why she was there, but it's a way that a reasonable person might be able to evaluate somebody being in a car. They could just merely be present there, and they might not know what Isaiah Chance is calling up Sean Gathright to see what Sean Gathwright's doing, right? So even if it could be interpreted one way or the other, if a reasonable person could say, well, maybe she was just there, they're arguing that that's enough. And according to this case law, no matter how flimsy that evidence might be to support that defense theory, the defendant is still entitled to the jury instruction for the theory of their case. So I'd say Florida case law seems to support that inclusion, even though I think a lot of people would disagree that that's actually why she was at the scene. So we've got, let's see, we were here. Thus, there was substantial evidence showing that Miss Andrews was merely present at the scene of the crime and the first prong was met. Second, the standard instruction did not include the language that the defense requested in the special jury instructions. Thus, the standard instructions did not adequately cover the theory of defense. Lastly, the special instruction was a correct statement of the law and was not misleading as to the language, as the language was taken directly from binding case law. So, this is just a good thing to include. When you can take the exact language from somewhere, and we'll see if the state replies on this specific issue, right? We're going to look for this. This is Penny v. State. This is a 2nd District Court of Appeals, so it's the same district court that's in Hillsborough that has jurisdiction here. And they took the language right from the case law. So it met that prong. The 4th District Court of Appeal found reversible error where the trial court refused to give an afterthought of instruction in a robbery case. So this is the Perkins v. State case. For that case, the court held that the failure to give a requested jury instruction on a key theory of defense, where there's evidence to support the instruction, requires a new trial. The standard robbery instruction was inadequate because without the instruction as requested by appellant in this case, or as given in Perry, the jury could not have understood the afterthought theory of defense. So this is a reversal again because of jury instruction errors. I'm telling you, they love it. They love it. Reversing a conviction where the trial court refused to give an independent act instruction. So they reversed because of that instruction issue. Next up, we have the trial court improperly denied defendant's challenge for cause against a prospective juror. Now, I think the jury instruction would be the issue I would hang my hat on. If I'm going to hang my hat on any issue, or maybe the cumulative impact of all the issues, right? Because you can also argue, hey, if you don't think any one of these issues alone, is enough to say that the outcome of the trial, we can't have confidence in it. What about if you consider all of the issues together? The cumulative impact of all of the errors. Is that still harmless, right? So maybe I'd say all of them, but if I had to hang my hat on one, it'd be the jury instruction thing. And not even just because of the way it's argued, but just because, I don't know, I feel like appeals courts don't like to overturn and say the judge made a bad decision. But, the jury instructions, the jury didn't think about it the right way. Like, I don't know, I just feel like they're inclined to take that path, if any. So we've got the trial court improperly denied defendant's challenge for cause against a prospective juror. There's a 2-pronged standard requiring an appellant to establish both error and prejudice to be granted a new trial based on a judge's denial of a cause challenge. So that's when you strike a juror for cause. And that's like, hey, it's obvious there's no way that this person should sit on the jury pool. We have a limited number of peremptory strikes that we can use Each side has a limited number of strikes that, without having to explain why, they can just say, we want to strike this juror. And they're not supposed to do so under any basis of like a racial pretext or a pretext involving any protected class status. But they can just be like, well, their face winced when we ask a certain question and we just want to use our strike on them. But if for cause, if someone's like, I love police and I'm never going to think police did something wrong, well, that might be a reason to strike someone for cause, because if you have detectives that are going to come take the stand in this trial, they're going to believe the credibility of that witness, not because of what they're actually hearing or observing that witness testify to, but just because they're law enforcement, right? So that would be a reason to strike without someone having to use their limited strikes. So they're going to argue that because you didn't strike this person for cause like you should have, we had to exhaust one of our limited strikes that we could have used on somebody else. So they say there was reasonable doubt as to whether a juror possessed an impartial state of mind. The test for determining juror competency is whether the juror can lay aside any bias or prejudice and render a verdict solely on the evidence presented and the instructions on the law given by the court. A potential juror must be excused for cause if there's any reasonable doubt as to whether the potential juror possesses an impartial state of mind. And then they have a quote here from, Hill v. State, providing that if, quote, any reasonable doubt exists as to whether a juror possesses the state of mind necessary to render an impartial recommendation as to punishment, the juror must be excused for cause. So the trial court erred when it refused to grant Ms. Andrews' challenge for cause against multiple jurors, including but not limited to juror number 6, a former state representative and sponsor of tough on crime legislation. Juror 6 made it very well known that he was and still is a staunch supporter of legislation that increased the amount of time that convicted felons spend in prison. So he probably was in support of what we have in Florida here called truth in sentencing. And we do have like an 85%, like if you serve 85% of your sentence, you might be able to get out. But we don't really have parole down here in Florida. It's if your sentence, especially if it's something that's relating to a 1020 life enhancement, where you're locked in because you're convicted of something where you used a firearm. Truth in sentencing is like, we want you to serve 100% of what you're sentenced to. So they're probably talking about legislation parallel, or if not that legislation itself. These ideas that it increases the time, not just of what you're facing, but also keeps you in prison for that 100% of the time if your crime involves certain underlying enhancements. So Juror 6 transparently shared his personal beliefs and professional efforts as they related to sentencing and due process. In his career, Juror 6 sponsored significantly harsh legislation geared at reducing the time that inmates spend on death row, ultimately minimizing a defendant's ability to seek appellate relief after trial. Juror 6 expressed little to no interest or previous support in legislation to the contrary. As this is a case where a life sentence was a genuine possibility, Ms. Andrews asserts that Juror 6 presented reasonable doubts as to his impartiality. His prior experience and views presented a reasonable fear that the jury would be exposed to potential consequences of a guilty verdict and improperly influenced in their deliberations. Despite the defendant's efforts to exclude Juror 6 for cause, the court denied the request, and ultimately Ms. Andrews was forced to use a peremptory challenge to remove Juror 6 from the veneer pool. That's the whole pool available that a jury is impaneled from. The court denied several other defense cause challenges that had merit. And I don't know, I kind of think like, if the jury didn't think she committed these higher acts, I personally wonder if some guy sitting there, if he decided to tell the jury, well, if she gets convicted of this, she's going to be facing life and nothing less. If she gets convicted of this, she's facing minimum of this, and she'll have to do jail time. I wonder if that could have caused some sympathy. And I don't think it would have pushed them to go higher. But again, at the time that they were selecting a jury, it's not like we knew what the verdict would be. And I think they did the right thing by trying to get somebody who's tough on crime for the sake of being tough on crime, not tough on crime when I think it matches all these things. They did their job wanting to get this person off the jury. So because he couldn't be struck for cause, they used one of their limited peremptories. So we've got next, the defendant was prejudiced by the court's failure to grant an additional peremptory challenge to the defense. Since Ms. Andrews was unable to use a cause challenge to exclude Juror 6, Ms. Andrews was ultimately forced to use a peremptory strike against Juror 6. The forced use of defense peremptory strike on Juror 6 and other jurors who should have been struck for cause resulted in the defense having to accept Juror 62, a juror that the defendant would have used a peremptory strike on, if granted by the court. During voir dire, Juror 62 explicitly asserted his inability to understand rap lyrics, an issue that turned out to be a central part of the state's case against Ms. Andrews. Based on that inability, the defendant believed Juror 62 would not be an appropriate juror in the present case, and the defense would have used a peremptory strike against him should the court have granted it, but they exhausted it already. They didn't have any more. Juror 62 ultimately sat as a juror in the trial. Thus, Ms. Andrews will likely be able to show error in the jury selection process. Now, I don't think that this is that strong of an issue. And part of that is because, all of we don't really have strong legislation here in Florida. Some states are starting to have it. We don't have a strong push here to stop using forms of artistic expression in prosecutions. So I don't know if this is really, this would not be an issue I would wage a bet on here. Then we have the appellate court's granting of the defense writ of prohibition show that the trial court committed reversible error. So now they're going to leverage the fact that the Second Court of Appeals said, yeah, we're going to disqualify Judge Sisco. They're going to leverage that here. And while I do think it's an event that triggers the clock where you can refile these motions, hey, we have a different judge. We want to ask you to reconsider some things. We want to have you reconsider these procedural motions for setting aside the verdict, granting a new trial, whatever. I think that's really what that decision triggers. I don't think a court of appeals disqualifying a judge is a finding that the judge specifically did these bad things, right? It's just that the defendant made a sufficient showing that she's in fear that she's not going to have a fair sentencing hearing or whatever else is coming up. But let's see how they argue this. So they've got, even if Ms. Andrews is not acquitted of the offenses, this court must grant Ms. Andrews a new trial. And they cite here a 3rd District Court of Appeals de Castro v. State is instructive. They say it tells us exactly what to do. In de Castro, as here, the appellate court addressed an appeal from the denial of a motion to disqualify the trial judge after trial. In de Castro, just as this case, the appellate court found that the trial judge erroneously denied a legally sufficient motion to disqualify the trial judge. The erroneous denial of a motion to disqualify the trial judge is subject to a harmless error analysis. In de Castro, the appellate court found that the state could not overcome the harmless error analysis because the trial judge made several consequential decisions that could have altered the outcome of the trial. Here, Judge Sisco did the same. Among other rulings, Judge Sisco denied the defense motion for special jury instructions, excluded defense witnesses, and admitted grave amounts of irrelevant and prejudicial evidence against Ms. Andrews. Thus, this court, at minimum, has to grant Ms. Andrews a new trial. So, from what I remember, the 2nd District Court of Appeals decision was like a paragraph long. And here we're specifying that in this case that we're saying relates in de Castro, that the appellate court made a specific finding that the state could not overcome the harmless error analysis because, so they make an additional finding that the trial judge made several consequential decisions that could have altered the outcome of the trial. I'm not sure we had that specific part. And maybe when we get to watching later, when we put the hearing on, I'll go pull up that order, but it was short. It was like a paragraph long. So let's see. Among other things, Judge Sisco denied the defense motion for special jury instructions, excluded defense witnesses, and admitted grave amounts of irrelevant and prejudicial evidence against Ms. Andrews. Thus, this court, at a minimum, has to grant Ms. Andrews a new trial. Let's see. Then we've got defendant was denied her right to a fair and impartial trial. And this is going to be the cumulative impact. So even if no single error warrants reversal on its own, the cumulative effect of the error is deprived defendant of due process and a fair trial. So they're citing here McDuffie v. State. In addition to the issues laid out more thoroughly above, 2 of Ms. Andrews' witnesses were not allowed to testify to relevant evidence in this case, an independent ground for reversal. So they didn't really flesh that out here. They mentioned it above, and then they like throw it in here. And then they cite Walker v. State reversed for new trial because trial court excluded witness testimony that was otherwise relevant evidence. So in conclusion here, Ms. Andrews respectfully requests this court set this matter for a hearing on the issues addressed herein. That's finally happening tomorrow. And after hearing argument, enter a judgment of acquittal, notwithstanding the verdict, or grant a new trial, or any other further relief the court deems just and proper. Now, I know we're going to read the state's reply. We're going to read our response. We're going to read the defense final reply to the state's opposition. We're going to watch a bit of a pretrial hearing about the domestic violence arguments. And if the judge is like, no, we're moving on to sentencing, what I would expect we will see, undoubtedly, is these arguments are filed. We'll see a notice of appeal filed, and then we'll see an appeal brief sent in, and we might have a little bit of changes to this document. It might have some issues expanded on, some reduced a little bit more, change of focus. But we'll probably see something very similar filed with the Second District Court of Appeal as the first appellate stage. So that's their arguments. And I think the jury instruction one might have something to it. And that's really outside of this case. I just see it over and over. These appeals courts and these judges are aware of what appeals courts do and what they look at. They just love when there's a flawed jury instruction. They really, really do. So next up, we have the state's response. And this was, let's see, we went from February 26th to April 3rd. April 3rd is when they filed this one in. Whew. So, let me get a drink. And was this Michelle doing this? Michelle Doherty? Okay, yep, so it looks like it's Michelle Doherty. She's got the signatory here. Even though it's submitted by Susan, we have the signature line here from Michelle Doherty. So, all right, so state's response to all of that. The state of Florida responds to the defendant's motion to reconsider. We're going to skip all of these long things. You guys know they're asking for all the things. And they would show as follows. The state would show as follows. The defendant was indicted on the 15th day of August in 2024 for first-degree premeditated murder of Charles Jones and conspiracy to commit first-degree premeditated murder of Charles Jones. The defendant was charged as a principal, along with her co-defendants. You've got Isaiah Chance, Sean Gathright, Rashad Murphy, and Davion Murphy, not Damian Smith. In addition, co-defendants Gathright, Murphy, the other Murphy, were charged with 3 counts of, and I'm thinking of this now, I should have thought about it at the beginning of the stream. Last night on PI Sam, it was a simulcast. It was on 2 streams, and it's in the Creator Friends playlist in the description. If you guys want to jump and go watch that. PI Sam and Trial TV, the team at Trial TV, they did an interview together. And PI Sam was part of Davion Murphy's team for this trial. And Scott Sonardi Jr., young Sonardi, who did the closing arguments, he's only 26 years old, for Davion, was in the chat answering questions as well. And it was really insightful. It was 2 hours long, a bunch of Q&A about, what went into this trial, what were some of the pre-trial happenings that made you guys shift your decision, why did you shift your decisions? And there was a lot of specifics, even though some things you can't get into. There's still some attorney-client privilege and things that Sam couldn't speak on. But that was a really good interview. So if you guys missed that, Trial TV and or look up PI Sam or go to the Creator Friends playlist in the description. They should be the most recent video I added to it. So that was really interesting last night. Sorry I forgot to mention it earlier. But yeah, as reading these names and the mix-up, because PI Sam made a comment about how during the reading of the verdict, we had the camera person on the wrong faces. They switched the Murphy brothers and were on the wrong face for the wrong reading. So that made me think of that. And they were charged with 3 counts of attempted first-degree murder in counts 3, 4, and 5. And Gathright was charged with 1 count of tampering with evidence in count 6. The state filed state's motion for pretrial ruling regarding admissibility of evidence on December 6 of 2024. So, just shy of a year before the trial actually happened. The state motion requested a pretrial ruling regarding the admissibility of the co-defendant's gang affiliation and historical rival gang war evidence, as it was inextricably intertwined evidence and evidence of motive and conspiracy to commit murder. The defendant filed several motions, including defendant's motion to preclude use of guilt by association evidence, defendant's motion and objection to exclude Williams rule evidence, collateral crime evidence, and inextricably intertwined evidence, and defendant's combined motion in limine. So they're going through all the procedural history here because they're going to want to show, look, they were able to raise all of their arguments and the court gave a fair consideration to these arguments, so you should deny reconsidering and unwinding what the previous judge decided. These motions were heard on the 19th day of December. They cite the transcript here and tell the court where they can go look up this event. The court's written order was signed on the 3rd day of January in 2025. All of these listed pretrial motions were heard and ruled upon well before the jury trial, which occurred in October of 2025. Prior to the trial, there were never any grounds for judicial disqualification raised by the defendant. Now, this I thought was a good argument. If you have, obviously, trying to disqualify someone before trial, if you then argue that there were issues at trial, you wouldn't know. You wouldn't be trying to move to disqualify somebody if you didn't realize there was an issue until trial started. So this argument doesn't really address the arguments that, hey, during trial, these things raise concerns. But since one of the requests is to reconsider pretrial rulings, the state's kind of making a common sense argument. If there were issues with pretrial rulings, why didn't you try to disqualify the judge before trial? If you're arguing that she was making such egregious mistakes before trial even kicked off. Fair enough, right? I think, so it's got some punch to it. The state filed state's motion in limine regarding prior instances of domestic violence between the defendant and Isaiah Chance, and motion to strike witnesses Jewel Jordan and Jaquela Robinson on the 12th day of August 2025. The motion was heard, and this is what we're going to watch later. So they cite the transcripts to that, but we're going to watch it. The defendant's trial commenced on October 20th, 2025, in front of the Honorable Judge Michelle Sisco. After a 2-week-long trial, the defendant moved to disqualify the trial judge before closing arguments were to begin on October 31st, 2025, Halloween. The trial court denied, and I looked, because I couldn't remember the other day. It was about 4 hours. It was just shy of 4 hours of deliberations for Alicia Andrews. So the trial court denied the defendant's motion to disqualify the presiding judge because it was filed the same day and denied, and the case proceeded to verdict. The jury convicted the defendant of the lesser included offense of manslaughter on count 1 and found the defendant not guilty of conspiracy to commit first-degree murder on count 2. The defendant filed a petition for writ of prohibition. We're going to skip this, but we know that those dates for disqualifying the judge. But what the state's emphasizing here is, what did the Second District Court of Appeal actually find, right? We had the defense just hint at, well, DeCastro said that the decisions could undermine the outcome of the trial. What did the Second District Court of Appeals actually find? The state here is going to say, well, this is it. It was a simple 1 paragraph, and they deemed it, quote, legally sufficient. However, the Second District Court of Appeal did not make any findings of facts as to veracity or legitimacy of the basis of the defendant's motion to disqualify the trial court. And again, I think this is a fair assessment from what I remember. The decision was this long. if the whole length of my screen is the paper, it was a paragraph like this. So there's only so much you can put in there. And then let's see. Initial motions for disqualification of trial judges determine, quote, only the legal sufficiency of the motion and shall not pass on the truth of the facts alleged. So it's not about the merits of what's actually being claimed. It's a prima facie. We're looking at it, and at a first glance, is it sufficient to say that, hey, yeah, we do see how the defendant could be concerned about a fair and impartial proceeding? On the surface. That's all. Since the Second District Court of Appeal found the defendant's motion for recusal was deemed legally sufficient, the chief judge was ordered to immediately appoint a successor judge to the case. The defendant filed defendant Alicia Andrews' motion to reconsider previous pretrial and trial rulings and second amended motion for judgment of acquittal, the thing that we just read on February 26th. All right, so let's get into more on the reconsideration. We've got Florida Rules of General Practice and Judicial Administration, 2.330J, allow for prior factual or legal rulings by a disqualified judge to be reconsidered based upon a motion filed within 30 days of the order of disqualification. However, we've got a quote, the purpose of successor judges' reconsideration of a disqualified judge's rulings is to remove the taint of prejudice where rulings might be perceived as so tainted, and that's important language, as so tainted. It should not be used merely to obtain a second bite at the apple with respect to prior judicial rulings. So you can kind of guess here, they're going to take this case law and they're going to be like, look, all Alicia Andrews wants here is a second bite at the apple. We don't have this level of, oh, it's so tainted, we have no other choice. This is just an attempt to try to get a second bite at the apple. And they're relying on this case here from the First District Court of Appeal. In the Agnenovic case, the appellant failed to demonstrate how the prior recused judge's order was based on a clearly mistaken interpretation of the law as required by Rule 2.330, and the successor trial judge correctly affirmed the initial trial court judge's ruling. Yeah, let's get some apples in the chat. There we go. One thing that sucks about moving down to Florida, I have not had a good apple in years. I don't even want a second bite at apples. I take one and the apple's like mush, even if I just bought it that day. I don't want a second bite of any apple anymore. The downside of not being in New York anymore. Anyway, back to the motions. Likewise, in the current case, the defendant has failed to demonstrate how any of the prior judicial rulings were incorrect and fails both requirements laid out in the Agnenovic case. First, the defendant has failed to establish that the prior judicial rulings were tainted by judicial prejudice. And I think I missed this line, right? Did I read that? That the recused judge's order was based on clearly mistaken, not just a maybe, but clearly, of the law as required. I did read that because I read that part. There we go. So what didn't we do here? What didn't Alicia do that would make it meet this case? So first, the defendant has failed to establish that the prior judicial rulings were tainted by judicial prejudice. Secondly, the defendant has failed to demonstrate any improper ruling or mistaken interpretation of the law made by Judge Sisco in pretrial rulings and trial rulings. To the contrary, Judge Sisco's rulings were lawful and correct. All right, let's read the next sentence before I comment. As to the defendant's request for reconsideration of the pretrial motions in limine, which were heard and decided well before the defendant's motion to disqualify presiding judge, was filed on October 31st, 2025. The defendant fails to meet both requirements laid out in the Agnenovic case. The state filed a motion for pretrial ruling regarding admissibility of evidence on December 6, 2024. The state's motion specifically regarded the admissibility of the co-defendants. So Chance, we have Garthright, his name is spelled wrong. Mr. Garthright, R. Murphy and D. Murphy. We don't use Oxford commas apparently here. Gang affiliation and historical rival gang war evidence, as it was inextricably intertwined evidence and evidence of motive and conspiracy to commit murder. The defendant was charged as a principal along with all of the co-defendants for first-degree premeditated murder and conspiracy to commit first-degree premeditated murder. And what's interesting here is, I do think it's interesting in light of the verdicts in the trial for the four, that Sean Garthright was found guilty of the attempted murders. Let's use the attempted murders, for example. But the gang affiliation attachment wasn't there. So, I think that's interesting. And then Isaiah Chance, for his first-degree convictions, well, I guess he's not really relevant for what I'm about to argue. But yeah, so we have these different verdicts, though, where we have a conviction for all four of these guys, where the back and forth was introduced in the case that all four were part of, and we get the first degree convictions even for one of the defendants who wasn't alleged to be part of or doing things for the benefit of a gang. So kind of interesting as a side-by-side looking back at this argument. The defendant filed related motions to this issue, all of which were heard on the 19th day of December 2024. In the defendant's motion for reconsideration, she refers to the motion in limine to preclude the state from introducing evidence of a years-long Jacksonville gang war, rap music videos, and various uncharged crimes the state sought to introduce. Pursuant to Florida Rules of General Practice and Judicial Administration 2.330, disqualification of judges, the rule requires any motions pursuant to this rule shall be in writing and must be filed timely, which means filed within a reasonable time not to exceed 20 days after the discovery by the party or party's counsel. So they're saying here it was timely. That's not one of the reasons it could have been challenged. As previously stated, defendant filed the motion for disqualification of the trial judge the last day of the trial on October 31st, 2025, months after the trial court had already ruled on state's pretrial motion in limine regarding the co-defendant's gang affiliation and historical rival gang war, and the defendant's related pretrial motions. There was never any basis or grounds to contest Judge Sisco's pretrial rulings on the state and defendant's motions in limine that occurred on December 19th, 2024, and memorialized by written order on January 3rd, 2025. The defendant has not alleged nor claimed any judicial bias or prejudice during the 9-month period leading up to the trial, and had such grounds ever existed, would have been required to file a motion to disqualify the court within 20 days after its discovery. So they're arguing here that they didn't raise an issue. They didn't have an issue with this the whole time. If it was truly an issue of merit, this is what they're arguing, they had 20 days to raise this issue, and they didn't do it. We filed all of our motions well in advance of the trial. It's not like they were panicking and had to go to trial. They had 9 months. They had 9 months to raise an issue, and they didn't do it, which, again, the argument here is they simply want a second bite at the apple. Clearly, based on the record, that did not happen, and therefore, I can hear this in Michelle Doherty's voice. Clearly, based on the record, that did not happen, and therefore, the rulings made by Judge Sisco in December of 2024 and January of 2025 cannot in any way be perceived to be tainted by any judicial prejudice. Since there is no taint of judicial prejudice that needs to be removed, the defendant is not entitled to second bite at the apple with regards to prior judicial rulings that occurred during that time frame. It is well settled, it's well settled that unfavorable rulings are insufficient grounds for recusal. And then they cite here Pilkington v. Pilkington, Housing Authority of City of Tampa v. Burton, Williams v. State. It should also be noted that the defendant received favorable rulings by Judge Sisco during the December 19th, 2025 hearing. Did I mean 2024? I think that must be 2024. Again, the defense filed no motion suggesting there was any improper rulings or bias or unfair treatment made by Judge Sisco prior to the last day of a 2-week trial, nor do any grounds exist. Now, so this is the sentence I highlighted above. I don't really see them so far arguing that the rulings were lawful or correct. They're just saying like, hey, it's clear they're only challenging this kind of in hindsight because they don't like that their client had a conviction at all. They want the second bite of the apple. But yeah, I'm not really sure they're making the argument that the decisions were correct. They're just saying they're only saying they're not correct because they want the second bite. So let's see. There we go. Again, the defense filed no motion suggesting there was any improper rulings or bias or unfair treatment made by Judge Sisco prior to the last day of a 2-week trial, nor did any grounds exist. The inclusion of these pretrial rulings in the defendant's motion for reconsideration is wholly without merit. And again, this whole paragraph so far is only addressing the request for reconsideration of pretrial rulings. This isn't addressing what happened during trial. Moreover, Judge Sisco's pretrial rulings were both correct and proper legal rulings based upon the law. The defendant's motion for reconsideration fails on this ground. It also fails on the second requirement. The defendant fails to list or demonstrate how these rulings are incorrect legal rulings. In the defendant's motion to reconsider previous pretrial and trial rulings, the defendant included these motions under motions in limine on page 2 of the motion, stating, prior to the start of the trial, the defense moved in limine to preclude the state from introducing evidence of a years-long Jacksonville gang war, rap music videos, and various uncharged crimes the state sought to introduce. And I do wonder, we had that footnote in the defense's motion where they said they were going to file a supplemental briefing, and I just never saw that hit the docket. So, I mean, maybe what they're saying is missing here is something that the defense was going to expand upon and then never did. Because we had that lingering footnote, if you guys remember, on the first page of the defense's motion. So we've got, let's see, the defendant fails to demonstrate how Judge Sisco made an improper ruling or ruling based upon a mistaken interpretation of the law. The defendant fails to support its claim with any facts, case law, or legal authority. The state's motion for pretrial ruling regarding admissibility of evidence regarding the co-defendant's gang affiliation and historical rival gang war evidence, and the defendant's related motions, such as the defendant's motion to preclude use of guilt by association evidence and defendant's combined motion in limine, were heard on the 19th day of December of 2024, not 5. The state's motion for pretrial ruling regarding admissibility of evidence regarding the co-defendant's gang affiliation and historical rival gang war evidence was filed citing case law supporting its admissibility as inextricably intertwined evidence, evidence of motive to commit the murder of the victim, and conspiracy to commit first-degree premeditated murder. It was clear that the court reviewed all the motions and supporting case law. And they're citing to, did they attach this exhibit here? Yeah, I don't see the attachment, so I can't see exactly what they're citing to here. That's supposed to show that the judge reviewed everything. It could just be like a line in the order where she says, after reviewing all of the, and that's what they're citing to. While the court granted the state's motion regarding the admissibility of the evidence, the court also limited the evidence that the state could put in, as the state was not seeking a gang enhancement against the defendant. So they cite to, again, this Exhibit 1 and a couple 2 pages from it. The defendant was not charged herself as a gang member, but was charged as a principal along with her co-defendants, some of whom were gang members, including her boyfriend Isaiah Chance. The court further limited the scope of the evidence from the gang war, which started in 2018 and earlier, to a date range starting in August of 2023, when a gang member named Jaquan Pickens was killed, and included the prior attempted murder of the victim, which was matched ballistically. So they're talking about the October 2023, the October 7th attempted shooting on Julio, which was matched ballistically to evidence recovered in this case, shell casings recovered from co-defendant Gathwright's vehicle, and other incidents that occurred in 2023, the year before these offenses. So they're saying, like, look, the judge even ruled against us. We wanted more to come in. We wanted to go all the way back to 2018 and go into this whole timeline, but the judge narrowed us. So the judge gave a favorable ruling to the defense, which shows that there's at least some application here of looking at things and not just being completely biased against the defense and their requests and in favor of whatever the state wants, right? And maybe this is the only example they give, I don't know. But after hearing from both sides, the court ruled, and now we have a quote, "I'm granting the motion in part, specifically as to conduct that occurred in 2023. The acts of violence between the parties, the rival gangs, I find is admissible collateral crime evidence as being inextricably intertwined. However, subject to, but it's without prejudice for you all to have the ability to renew specific objections to any specific items of evidence once the state has given you their exhibit list." And then, after further requests for explanation by the defense, the court clarified. Okay, so here are the 4 factors for collateral crime evidence to be deemed necessary. 1, to adequately describe the deed. I find it necessary, 2, to provide an intelligent account of the crimes charged. I find it necessary, 3, to establish the entire context out of which the charged crimes arose, and I find it's necessary to establish for the state to adequately describe the events leading up to the charged crime. So I find all 4 factors of admissible collateral crime evidence as being inextricably intertwined to apply in this case. The court also heard and ruled upon the defense motions, which included related motions to the state's motion regarding gang activity and historical rival gang war. In the defendant's motion for a new trial, the defendant argues that Judge Sisco committed reversible error by denying Ms. Andrews' legally sufficient disqualification motion, and the error was not harmless because the judge made several consequential decisions that could have altered the outcome of the trial. To be clear, all of Judge Sisco's pretrial rulings made months before the trial certainly cannot and should not be reconsidered, especially because the defendant made and raised no claims regarding pretrial rulings made over 9 months before the defendant's jury trial. All the alleged claims of bias made by the defendant in the defendant's motion for disqualification occurred during the jury trial. There were no allegations of judicial bias or prejudice to the defendant or defense counsel that occurred prior to the defendant's trial. As to Judge Sisco's ruling on the state's motion in limine regarding prior instances of domestic violence between the defendant and Isaiah Chance, and the motion to strike defense witness Jewel Jordan and Jaquela Robinson, the state filed the motion on the 12th day of August of 2025. This motion was heard on the 13th day of August of 2025. And then we're going to watch that. The state filed the motions after taking the depositions of defense witnesses Jordan and Robinson, both of whom testified to prior instances of prior domestic violence between the defendant and one of her co-defendants, Isaiah Chance. Both witnesses never witnessed any acts of domestic violence, but were told after the fact of the alleged incidents of domestic violence by the defendant. The state filed the motion based upon grounds of relevance and impermissible hearsay. The state argued that any acts of domestic violence against the defendant by another co-defendant was not relevant to any material fact at issue in the trial, as duress is not recognized as defense to the first-degree premeditated murder and conspiracy to commit first-degree premeditated murder. Let's see. I always think that this is tricky, though, because the idea that you couldn't be under duress if you planned something for like a long time is super premeditated. It wasn't just like in the moment you decide to do something. But then if you ultimately send a lesser included back to the jury, but you precluded this type of evidence to come in on the grounds that it wouldn't make sense under a theory of first degree, but now it makes sense by the time it's deliberation time, I don't know. I think that's just kind of messy in general. I can imagine that being a problem in several cases. So they say this is not a domestic violence case in which the defendant is claiming any sort of self-defense claim for killing her abuser. The defendant is seeking to admit incidents of domestic violence that occur between her and one of her co-defendants. It is the state's position that any evidence of domestic violence between the defendant and her co-defendant that occurred months prior to these offenses before the court are not relevant to the first-degree homicide and conspiracy to commit the first-degree homicide of an unrelated victim, but only used and elicited by the defense to blatantly garner sympathy for the defendant and inure the defendant to the jury. And I think their theory was more to explain why she wouldn't question what was going on, why she wouldn't ask. It was a general pattern of wanting to avoid arguments that may sometimes turn violent. But the idea, I don't think the defense's position was that she went on this Tampa trip and was sitting in the car that day because he was threatening to beat her. Like, I don't think that's how the defense argued for admission of this, but we'll see what you guys think when we watch that hearing. But again, that's what the state's representing, that the defense was their premise for wanting to introduce this type of testimony from the friends. And I disagree with their characterization on that part. The defendant argued back in the hearing that the evidence was relevant to the defendant's state of mind and made it clear to the court that he did not intend to use it for a duress defense. All right, so they concede that. After the hearing on August 13th, 2025, Judge Sisco granted the state's motion without prejudice, allowing the defense attorney to revisit the issue if he calls the defendant and it becomes relevant. So you'd have to put her on the stand if you want to be able to use this. Simply requesting that the defense needs to talk about it before he gets into it. In addition, Judge Sisco did not strike the defense witnesses, but reversed ruling on it. During the course of jury trial, Judge Sisco did revisit this motion again on October 20th, 2025, during jury selection, outside the presence of the panel, favorably ruling for the defendant, reversing her previous ruling to a limited extent, and allowed the defendant to present evidence of domestic violence under certain conditions, and again made it clear that duress was not an available defense. So I didn't actually realize it was in the middle of defense already, because I mean, I don't know the specifics, but if this is like we already started doing voir dire questions, maybe we agreed to keep a witness, maybe we were almost done, maybe we'd already struck a witness. You know, knowing this before jury selection started could have changed the way you voir dired the jury and what types of questions you would have asked. So I'm not sure that this makes it better that we raise the issue in the middle after trial's already underway and we're picking a jury. But, you know, the state's here arguing like, hey, she actually did give some leniency on this issue. She came back and said, oh, you know what, you can do it a little bit. You can have a little wiggle room here. But I don't know. So we've got, next, the court says, this is a quote, We did have the discussion about the issue of domestic violence involving Miss Andrews at the hands of Mr. Chance, and I did indicate that you all would be permitted to question these jurors to see if they've ever been victims or know anybody that was a victim, or if they've ever been accused of domestic violence. And I did take a look. We don't have to get into the weeds of it right now, but I did take a look. These cases are very instructive on this topic. And I think we saw these same cases in the defense's motion, Wright v. State and Hunt v. State. So we've got, and both of those cases stand for the proposition that duress is not a defense to homicide. However, it can be a defense with regards to premeditated intent to kill, and I anticipate that it could also be argued that it could be a defense as this defendant's charged with a conspiracy count, whether or not there was an intent to enter into a conspiracy to murder with the co-defendants. Okay? So I'm just letting you guys know that's what the case law says. Case law is absolutely clear. The case law is absolutely clear that duress is not a defense to homicide, particularly the lesser of second-degree murder and manslaughter. And then Ms. White says, Your Honor, could I have the cites again? Mr. McLymont says, I have them. Ms. White says, never mind. The court, okay. And I believe we had discussed earlier that the only way that was going to be a defense that was pursued, the history of domestic violence, only comes in if Ms. Andrews testifies. All right, I'll be back in a few and we'll get going. And again, that's from the middle of jury selection, like day one-ish of trial. So before openings. This ruling was favorable to the defendant's position. Is it? Do you guys want to do like a 1 through 10 vote? Like, how favorable is this really to the defendant's position? 0 would be not at all. 1 would be like the slightest teeny tiny bit. 10 would be extremely favorable, right? So what do you think of just this tweak up here, this paragraph we just read? How favorable do you think that is to the defense? Meaningfully. We've got the citation to where to go check this out. And then here the defendant has failed to show that Judge Sisco's ruling was prejudice or bias against the defendant or defense counsel. In addition, the defendant has failed to demonstrate that Judge Sisco's ruling was incorrect. It was addressed again during the trial on October 22nd, 2025. The court said, yes, all right, while we're waiting, I just want to make sure we're clear regarding my ruling regarding the allegations of domestic violence as a potential duress defense. I indicated yesterday that defense could, if they choose, talk about that with the understanding that evidence only comes in if the defendant testifies. There had been a previous motion for order in limine regarding prior incidents of domestic violence between the defendant and Isaiah Chance, and motion to strike defense witness Jewel Jordan and Jaquila Robinson. That motion was granted without prejudice to revisit if that testimony becomes admissible. So that ruling stays in effect. So if Ms. Andrews decides to testify, and if the state cross-examines her, and it appears that the state is challenging whether or not these allegations of domestic violence occurred, then that would open the door potentially. So look at how, let's run this back. She's reiterating her ruling. She says that still stays in effect. I'm reminding you it's still in effect. When is the tipping point, though, that this could come in? Because the way she says this next line is it's not the defense's decision to have Alicia Andrews testify about it. By putting her on the stand, it would not be enough to open the door. It would only be the door opening if the state challenges her and says something that then on redirect, the defense should now have an opportunity to have their client Q&A about. So I think this makes it a less favorable ruling than it was, apparently, according to the state. Let's run this back. The ruling is still in effect. So if Ms. Andrews decides to testify, and if the state cross-examines her, and it appears that the state is challenging whether or not these allegations of domestic violence occurred, then that would open the door, potentially, to the defense being able to call these other witnesses to support the challenged or the credibility of Ms. Andrews' testimony that she was abused by Isaiah Chance, okay? But at this point, it's inadmissible unless the door is opened. And it's not within the defense's range to open that door. So is it really something that gives them a favorable opinion? Because now that I'm reading this, a denial of such right, if the defense tries to say, oh, well, you never experienced any type of coercive pressure from Isaiah Chance, did you? And the opportunity to redirect and counter that was denied, that would be a whole separate can of worms. That would be an issue of, judicial error to deny at that point. So I really don't think that this decision by this judge being framed as a favorable ruling for the defense is a fair assessment. Yeah. Anyway, so they say, and then it's opened, and then we'll discuss it before those witnesses can testify. So then there's still all this red tape, possibly, potentially, that it would even mean Jewell and Robinson could be called. Do you want to do the 1 out of 10 again, you guys? A 0 out of 10? I don't know what you guys are actually voting. Yeah, you guys weren't really with it anyway, were you? FFS is negative 187, not 187. Let's see. And then we do have a 7 out of 10. There we go. See, I want to revote here from Posh. So we've got... Let me get back to my place. They cite the transcripts here. The court went to great lengths to explain the court's ruling to defense again, including citing case law after denying the defendant's judgment of acquittal argument. And then we have more. So, okay, I'll deny the motion for JOA. So, with regards to, we've had multiple discussions about the victim's state of mind. They're saying that that's how Sisco said it. So, she's supposed to be talking about Alicia here. Called her the victim. I'm going to repeat that, which is just interesting in the context of this argument about DV evidence admissibility. I'm going to repeat that there is no defense of duress in the state of Florida for homicide. And that's stated explicitly in Carujo versus State. The 2nd District Court of Appeals said coercion is a recognized defense to a criminal charge, except where an innocent life is taken. There is one case out of the 3rd District Court of Appeals, Wright v. State, and I think we've discussed this previously. The 3rd District Court of Appeals reiterated there's no duress defense in an intentional homicide case or any homicide case whatsoever. That's odd to me. Because, I don't know. What if someone had a gun to your head and told you, you need to, unalive, kill this person, or I'm going to shoot you? And that person happens to be innocent, but you choose to, save yourself. That's not a defense. You can't argue that as a defense at trial, that that's the reason you chose either it was them or me, or I was going to die. It just seems kind of odd. And I'm not saying that by it being a defense someone can argue at trial that it should mean that they shouldn't be charged. I'm assuming that person would be charged and have to make their arguments, and it might be like, oh, you'll get a lower charge and not a higher charge. And I understand why it might not apply for a first-degree premeditated, because chances are you're not planning this whole scheme the whole time under duress, right? The duress goes away at some point. But again, we had second-degree murder in play here. We had manslaughter as a lesser included as well. Like, I don't know, this is just kind of an odd conclusion to hear that a court of appeals doesn't think that duress could, like what if someone hijacks your car, but you're still driving? Like, they get in the passenger seat and they make you drive with a gun to your head. And they're like, go, 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 and you accelerate and you kill somebody trying to drive away. Can you not raise the defense that you had a gun to your head? Like, I don't know. I feel like I'm missing something here. I feel like I'm missing something. Or maybe this isn't what the case law, the Third District Court of Appeals actually held. But, like, I would be sad if we watched a trial where some helpless person is on trial for running someone over because they had a gun to their head. I mean, maybe the hope is the state wouldn't bring charges against that person. I don't know. But, like, the defense wouldn't be able to raise that defense. It just seems weird. It just seems weird. Anyway, that's my rant on that. They say, let's see, that court stated Florida has recognized the common law defense of duress as a defense to crimes other than homicide. Okay. The common law has steadfastly refused to recognize any compulsion, even the threat of death, as sufficient to excuse taking the life of another. Legal recognition of duress as a defense to crimes other than homicide necessarily assumes a working hypothesis that a harm or crime of greater magnitude is avoided when the subjected person succumbs to duress. So duress is not a defense in a homicide case. However, in the same opinion, the court did discuss duress as negating state of mind. And specifically, that court stated, having decided duress is not a defense to the intentional killing of another, we now address the question of whether evidence of duress, even though imperfect, which serves to show that Wright did not act with a premeditated design to kill the victim or with a deprived mind, required us to reduce to defendant's conviction for second-degree murder to a conviction for manslaughter. Okay, so it's there somewhat. Like, it's not going to be a full justification, but it'll change, like, the mens rea and, like, the classification of, the jury's going to decide between what type of homicide. The answer to this question depends, in our view, on whether the person, such as the defendant who aids and abets another in the commission of a murder, must herself be shown to have the state of mind required for the homicide, because we find the rule in Florida to be that aiders and abettors may be convicted either upon proof of their own state of mind, or upon proof that they knew that the person aided had the requisite state of mind. Evidence that the aider and abettor knew that the principal had a premeditated design to kill or a depraved mind will support that the aider and abettor's conviction for first or second degree murder. So, and this gets us back to more of it wouldn't make sense as a theory as against first degree, like a premeditated. But again, the jury was able to ultimately consider manslaughter by the end of it. And it's kind of weird that you can't get into the state of mind discussion because it doesn't make sense for first degree, but then you ultimately send a lesser back to the jury and you didn't get to introduce testimony or other evidence that would be a defense to that manslaughter consideration. So I don't know. It's just like so tangled to me. And it's a lot of like overlapping things. It's like you kind of try to solve one problem, but then there's another problem from another angle. And essentially in that case, the court seemed to open the door to at least the possibility that some type of threat or harm could be admissible or go to the defendant's state of mind, okay? Which is why I ruled initially that way, that I did, and I told you guys then, I said, listen, you can get up in opening statements and you can make this point, but this only comes in if the defendant testifies, because all that's relevant is her state of mind on the date of the offense and why she did or didn't do something. Nobody can come in here and extrapolate and say, well, they used to fight a lot and he would have beat her up and therefore she must have been scared. That's inadmissible. It's irrelevant. And it's just so interesting because, like, it's just such a weird way to watch a court view DV claims through this lens. It's irrelevant. And as I indicated, if the defendant, because under this, I feel like we should have greater challenges to the admissibility of experts that are called to testify to why someone who's claiming to be a domestic violence victim, maybe Courtney Clenny with the battered spouse defense she's planning to rely on, also a Florida case. maybe we should apply some of this logic to that. Or when the person accused of perpetrating DV is on trial and the victim testifies and then a DV witness is called to explain why they didn't leave, why they might have called their abuser multiple times. They bring in these past acts that are weeks and days and months and sometimes years removed from the date of the offense that's actually on trial. So I feel like this is another like wishy-washy application. So she's saying that's inadmissible, it's irrelevant. And as I indicated, if the defendant testifies that there were issues of domestic violence between her and Mr. Chance, and that's why she was in fear, and if the state cross-examines her to the point that it appears, and it's an and if, that they're challenging whether that domestic violence actually occurred, then the door would be opened for the defense to call other witnesses to support that. At this time, there's nothing in the record that she was in fear of anything. Nothing to do with her state of mind. So, okay. And then Mr. McLymont, this is still like transcript. So for the record, the defense has never requested to use duress as the defense in this case because I am also aware of the case law. I've never asked for a duress jury instruction. I do not intend to ask for a duress jury instruction. What we asked for was to show the previous abuse to show Ms. Andrews' state of mind in this case, which is very relevant in a first-degree murder case. That is what we asked for from the beginning. This was never, I want to put up domestic violence as a defense to the first-degree attempted murder. I mean, first-degree murder and conspiracy to commit first-degree murder. That was never our position. In this case, Ms. Andrews, and what the state has done on redirect of Detective Ramos, is ask him, show him text messages of Alicia yelling or cursing at Isaiah Chance, her former boyfriend, in an aggressive manner, and asking Detective Ramos, does it look like Ms. Andrews was afraid of Isaiah Chance a week before? This is not the day of. This is the week before. They've asked that question. So, in my view, they've opened the door to any of this stuff to come in. They've made it relevant, her state of mind, whether she was afraid of Mr. Chance. So, this is one issue to the side. The second thing is if it is relevant, which it is, Ms. Andrews' state of mind, that evidence should not be blocked and only filtered through Ms. Andrews. Of course, another witness cannot speak to an individual's state of mind, but they can speak to the incidents that they have been a witness to, and they can speak to the abuse that she suffered. They just cannot make the connection to say that because she was part of, and then it says the court. But if they can't make the connection, then why should they be able to testify to it? If they can't make the connection, why is it relevant? So then are you going to stand in front of the jury and make the argument, well, extrapolate, jurors, even though we don't have any evidence in this case that she was scared, to extrapolate that these witnesses said, and then, therefore, you should assume she was scared, which is why she did all of this. Is that what you're planning on doing? Jeremy says, no. And what you're describing is sort of the circumstantial evidence that the state is presenting for this trial and asking the jury to make inferences and extrapolate the evidence to come to the conclusion Miss Andrews is guilty of these crimes. The court. Well, do you have any case law on point that allows you to do what you're asking to do? Mr. McLymont. That allows a witness to testify about what they witnessed? I mean, case law would be that it's relevant. Give me a second. The court says, okay, and state, what's your response? So Michelle Doherty says, Judge, first of all, we did not open the door. Mr. McLymont specifically asked on cross-examination of the detective whether or not they asked if she was fearful of any of her co-defendants. That was brought up by Mr. McLymont. As far as, again, these witnesses, Jewel Jordan and Jakayla Robinson, they did not witness any of the abuse between the defendant and Isaiah Chance. All that they had was information that was relayed to them after the fact by the defendant, and the time period for that was months before. In fact, for most of what they could not give a time period. I think the earliest or latest that they could give was April for when they last saw, I guess, a photograph or saw her on some sort of FaceTime. So, Judge, our point would be that it does go to relevancy at this point. There is nothing, if we're talking specifically about her state of mind when this homicide is occurring. They have no knowledge about that whatsoever. And then it cites trial transcript here. And then says this conversation continues on pages whatever. And now we're back to argument. So the quote kind of just ends all weird. It's odd formatting. So all of this was like a quote from the transcript, and now we're back to the motion argument. So we've got this conversation continues with Mr. McLymont continuing to argue that domestic violence perpetrated against the defendant by another co-defendant is relevant to the defendant's state of mind. The court patiently listened to both sides of the argument and then made a ruling based upon the law citing to case law. The court stated, Okay, but here's the thing. Listen, I don't make the law. Here's the direct law. Roble v. State. The appellant argues that a defendant in a criminal trial has a right to introduce evidence to show his good character. The court cites to... this isn't exactly good character evidence. That's not at issue. The court then cites to 90.404, which states when character evidence is admissible. Character evidence. Generally, evidence of a person's character or trait of his character or her character is inadmissible to prove that he acted or she acted in conformity with it on a particular occasion, except, and one would be character of the accused, evidence of a pertinent trait or the character offered by an accused, or the prosecution to rebut that trait. This argument, however, omits the pertinent reference to section 90.405, which provides the methods of proving character. The statute reads methods of proving character. 1, reputation, and then 2, specific instances of conduct. In Florida, the methods of presenting character evidence is limited to the testimony of reputation. A defendant may place at issue his general reputation for being peaceful and law-abiding citizen. That's it. Defense counsel proceeds to provide the court with additional case law for his position, to which the court replies that she will review them. The court again makes references to the case law, which allows the defendant to be able to present evidence of domestic violence / duress in their case, citing to footnote 9 in Wright v. State, a case which suggests that while the intentional killing of an innocent third party is always criminal, duress should serve at least to mitigate it to something else than murder. It should be noted that the defendant was called as a witness by the defense and did testify as to several instances of domestic violence between her and her co-defendant, which she did, Isaiah Chance, which included introducing in front of the jury photographs of her with bruises that she received after Isaiah Chance hit her. The defendant testified that Chance was controlling and told her that what she could post and what she could wear. In addition, the defendant was allowed to present text messages from her alleged abuser, co-defendant Isaiah Chance, which demanded that she stop effing posting yourself, goddamn. The defendant continued to testify about how jealous and angry Chance was during her relationship with him. Yet, surprisingly enough, the defendant testified that she wanted to go to Tampa with the defendant. She probably said, Tampa. Tampa. Then the defendant proceeds to testify as to everything she did with the co-defendants while she was in Tampa. Notably, never once stating that she was in fear for co-defendant Isaiah Chance during the time that the offenses were committed. But this is why I keep saying I think they were missing the defense's argument. The defense wanted to explain why she would stay upstairs in the room, right? Where she might not be around to overhear if they were saying anything downstairs, right? And why she might think it's weird. She just wanted to go get ice from the kitchen and they looked at her weird, right? So they're addressing a different premise than what the defense is saying their intent to want to discuss any of these things actually would be. So they say that then the defendant proceeds to testify as to everything she did with the co-defendants while she was in Tampa, notably never once stating that she was in fear of Isaiah Chance during the time that the offenses were committed. When asked directly, but she said she didn't know what was happening, right? So again, I think we're missing part of the argument in retrospect. So these motions were argued before this testimony, and the state's including them here to be like, hey, she actually got to talk about this stuff, and also we didn't even hear that she was. So it turns out that even if the judge wasn't sure and made a ruling a certain way, we find out because of her lack of certain testimony that she didn't express fear. But the issue was she didn't know. And the defense was trying to show why she wouldn't ask probing questions or start nagging or like, show me your phone. What are we doing here? Why are you talking to Sean? Who are you calling? Why do you need my phone? Because it was just her habit. She just stopped asking those things of him because it always turned into a fight. And that's just the one defense that the defense wanted to be able to raise. It's just a theory that might not necessarily be the dynamic at play, but I don't feel like the defense got to fully get into that. And that's really what they were asking. That's the heart of their request, to get this type of information in. And I do think it's a distinct argument than, oh, they're just trying to rely on duress. She was forced in that moment and she knew what was going on. Because she described it as something like she heard the shots going off and asked Chance, she finally asked the question, What was that? Did you hear that? And he just was silent. He didn't want to talk about it. So if we're going to talk about her testimony, it's not that she had based on her testimony in a bubble, there's nothing from her testimony that would suggest she should have been in fear before those shots were fired. Because even when she heard shots, according to her testimony in a bubble, she wasn't sure what it was and asked a question about it. So how would that explain how she could have been in fear beforehand? But yeah, that's, these motions will argue everything within the premise of where somebody starts off standing. So I think we're missing out. We can't see why defense would argue for something like that because we're only seeing it through the lens of our own theory of the case. So, and I like seeing the theory, like the lens through both directions, because I want to know how to argue against one way or the other, right? I just want to see how people would argue if they realize what they're supposed to really be arguing. And I don't think this is addressing the intent of the defense's request. So anyway, they say, when asked directly on cross-examination if the defendant was afraid of Isaiah Chance when being interviewed by law enforcement after the crimes, she stated, "No, he's not even there, so why would I be?" Again, when asked if she was afraid to give up their names because she was afraid of Chance and the Murphys, or if she was protecting him in the interview, she responds, "I wouldn't say I'm doing any of that. I mean, I understand it's about a gang. I'm a female. I don't want to be in the middle of it. So I didn't answer, and I don't know for sure if they did anything at the time of that, so I didn't say anything." So again, the state probably thinks she's lying with this testimony, but the flip side, if you view it through the lens, just take what she says at face value, she's giving a reason why she might not have started yapping about, "Oh, my boyfriend was in a gang and he was gangbanging." She's like, if he is, I didn't know anything, and if he was, I wouldn't want to be in the middle of that, so I wouldn't know, even if I wondered if he was. Right? So if you view it through the two different lenses, you take this testimony two totally separate ways. So we've got the defendant's response to the prosecutor's question certainly was not that she was afraid of Isaiah Chance or any of her other co-defendants. At this point of her cross-examination, she said she did not identify her co-defendants to law enforcement, not out of fear of them, but because she did not know at the time if they actually did anything. Note for if you didn't know that they actually did anything, why would it even get to the level of you having to decide, I know they did something, but let me decide not to tell the truth because I'm scared, and let me tell them I'm scared. And if I tell them I'm scared, they're going to figure out that I'm scared because something probably happened and I know about something. Like, this is just bad circular logic. It's good circular logic to say, I think this is not a credible answer. You can deduce that this is not a credible answer and think that she's lying here. But again, this is where the state is claiming this quote proves that she wasn't afraid of Isaiah Chance, when if you take it at face value, it might only prove that she had nothing to tell, and that's why she didn't say anything at all. So they say, note for a list of lies that she told law enforcement during her interview, and then see Detective of Juan Ramos. Fear of Isaiah Chance and her other co-defendants did not come into play at all. If you're really afraid of somebody, you're not going to snitch in an interview. By her, if you believe that she had knowledge and she was lying during this interview, I think that could strongly support why she would lie and not say that she was afraid. Because as soon as you say you're afraid Isaiah Chance is going to come at you if you tell them anything, what is Juan Ramos supposed to conclude from that type of statement? That you know for a fact that Isaiah Chance did something. That's why you're saying you're scared. Like, this is just not common sense logic, this argument to me, and I'm struggling with it because it's just so antithetical to common sense. But they're trying to leverage what they have available and frame it in a way that supports their argument here. Immediately after the defendant's response, and this is one of the minor things, the defense motion didn't really go into this issue all that much. And so far, it's been the biggest portion of these 13 pages that we've gone through. So immediately after the defendant's responses, the state pointedly asked her, "Then why are you up here testifying about how Isaiah Chance hit you?" Again, the defendant does not respond that she is afraid of him. She responds, because I mean that leads up to why I acted the way I acted. I'm out of town. After asked directly again, you were afraid of him or not? Are you afraid of him? Does he beat you, and are you afraid to stand up to him? The defendant replies, yes, at times. The defendant was confronted with messages that she sent on July 17th, 2024, through a phone application to the person she claimed to be afraid of and controlled by, Isaiah Chance. The defendant messaged Isaiah Chance. Oh, I said, because this is her reading it. I don't think O is part of the text message or this. This is like the start of the message here. Bitch, you a sicko. Why you blocking me over a call? I didn't even initiate, trying to act like you mad, and I make people comfortable. I didn't do shit to make anybody feel uncomfortable. It was out of the fucking blue. Why the fuck are you acting like it's my problem? You wanted to have a reason to talk to them ugly bitches you talk to. Everybody you come across and touch, you fuck them up. You're not even mentally there. You're not even mentally there and stable in the head for no relationship, even when I didn't do shit to your ass or start a conversation. You still fucking mad, the fuck? And then I said you acting like I'm not pregnant. You gonna talk to me one day, so I don't fit. I think it's supposed to be give a fuck about your attitude, and I say, bye, bitch. So we quote that whole thing. It says there are no references in the defense's closing argument with regards to how the alleged domestic violence perpetrator by the defendant's co-defendant and boyfriend Isaiah Chance affected her state of mind, and that she only participated in the offenses, booked the Airbnb, provided her phone to Chance, and acted as a lookout at 3 locations because she was afraid of Isaiah Chance, due to all of the times he hit her and left bruises behind her face. I remember Jeremy talking about in closing that she didn't know what was going on and she wouldn't ask. So again, like, this might be true, but you're ignoring why the defense used testimony like this and the way in which they used it in their closing arguments, because it's not part of the lens through which you see the case. In fact, he argues how the defendant is completely innocent and willingly went with Isaiah Chance to Tampa and did not know anything with regards to what he was doing or going to do, similarly to the testimony provided by the defendant herself. Not only has the defendant failed to show how the court's ruling is incorrect, after having been given multiple explanations by the court regarding the limited admissibility of domestic violence evidence in the case, along with receiving lengthy explanations and being provided with the case law citations, it is beyond belief that the defense did not know and understand the limitations of the admissibility of the domestic violence evidence. It is clear that the domestic violence incidents were only admissible to the defendant's state of mind if the duress, the fear of her co-defendant, served to at least mitigate it to something less than murder, maybe reducing the defendant's intent to manslaughter. Yet they elicited the testimony anyways, knowing that duress was not available to them, and that it did not meet the requirements of admissibility per the court's ruling and case law. It was never conceded that the defendant or defense, maybe it means by the defendant or defense, that the defendant knowingly participated in the offenses and only did so because she was fearful of the defendant. The defendant put on evidence of multiple instances of domestic violence, along with photographs, knowing that the defendant would never admit that any of the actions that she did during the offenses were due to her fear for co-defendant Isaiah Chance. The defendant maintained her innocence and testified that she did not know anything about what her co-defendants planned or did. It is beyond disingenuous. Part of the reason I'm so passionate about this argument is because they're not addressing the arguments that actually got detailed in what they're replying to. This is a response to the defense's motion, and they're so focused on this one issue and not any of the others. But secondly, imagine a scenario where Alicia Andrews snitched during, let's say, like, she knew everything. She knew the whole plan, and as soon as she was caught up, she told Ramos and the other guy that was there, I forget his name, everything. Tells him everything. And Michelle Doherty says, well, we're going to call Alicia Andrews in our state case in chief as a state witness because she's cooperating. All of this that Michelle Doherty just said about DV this, DV that, you're not saying that, you're not relying on why you're scared, she would be arguing the exact same thing to the jury. She was afraid to say anything because he would hit her. She didn't ask questions. She just went along. And the state, in that role reversal, if Alicia was willing to play ball through their lens of the case, They would be saying the exact opposite of everything that they said here. And again, my gripe with this just goes beyond this particular case. But I really don't like the way prosecutors, the government, will pick and choose who they want to see as a victim at a certain point in time based on whether or not that person's helpful to their case. And if they're not helpful to their case, broad stroke, we can disregard them as a victim. And if they can be helpful to the case, we're going to dress them up at times as a victim to downplay their involvement, to downplay the crimes that they may have been complicit in. And we're going to upplay why you should hold the other person we've got our sights on accountable, because that's the big fish that we want to get. And I really don't like that bounce back and forth type of interplay that prosecutors seem to take depending on what role a witness is going to play or not. So yeah, anyway, they say it's beyond disingenuous that the defendant claims or argues that the court's pretrial and trial rulings regarding the domestic violence incidents are prejudicial or incorrect legal rulings. Again, in the defendant's motion to reconsider previous pretrial and trial rulings, the defendant simply states that, quote, Judge Sisco and the state erroneously and repeatedly framed the defense request as an attempt to use domestic violence as a vehicle for a duress defense, without supporting the false assertion with any case law or legal authority. I don't know if that's a case law assertion, though. If you're saying somebody's mischaracterizing something, that's not a legal argument. You're not hearing my argument. So why would you tack on case law to point, if you're just pointing out to the court, hey, that's not what I'm saying? Instead, the record clearly shows the defendant used this evidence as improper character evidence to garner sympathy. The defendant had been previously advised by the court on this issue multiple times about the limitations of the admissibility of evidence of the defendant's character. As shown by the record, there was no concession by the defendant that she acted during the offense out of fear of her co-defendant, which would have been the only relevant purpose of this evidence to negate her intent from premeditated murder to something less. But that's exactly why she put it on. It was to show that her presentation was that she didn't even know it was happening. She just heard these gunshots and asked, did you hear that? This evidence was elicited by the defense for an impermissible purpose, to blatantly garner sympathy for the defendant and to inure the defendant to the jury. The defendant has failed to show how the defendant was prejudiced by the court, especially given that the court changed its ruling to defendant's favor during the trial and allowed the defendant to admit the evidence of domestic violence, nor has the defendant shown that the ruling was incorrect. And yeah, I mean, I agree that they didn't go into this really in their motion, right? I do agree with that. They didn't really opine on why they think the ruling was incorrect, but they simply stated the judge had the wrong interpretation of what our initial argument was. So, I mean, that's not really where you enter case law. You're just arguing that the decision was based on a different premise than what we even put forward. So, defendant's second amended motion for judgment of acquittal, notwithstanding the verdict. So, we've got Florida Rule of Criminal Procedure, Rule 3.380, allows for the defendant to move for a judgment of acquittal if the jury returns a verdict of guilty, if the evidence is insufficient to warrant the conviction. The motion must fully set the grounds on which it is based and be made or renewed within 10 days after the reception of the verdict. The defendant did move for a judgment of acquittal and then timely filed the defendant's renewed motion for judgment of acquittal within the time requirement. The defendant argues that Ms. Andrews never conspired with her co-defendants to kill Mr. Jones and that she did not even know two of them. She didn't know the Murphys. In addition, the defendant argues that the only co-defendant that she had a relationship with was Isaiah Chance. When the defendant discovered that Chance was going to Tampa, she wanted to go with him and did not know about any murder plot to kill the victim. The defendant claims that she believed that she was going to Tampa to spend time with Chance. The defendant claims that she did not provide any assistance to any of the co-defendants, but was manipulated several times into allowing Chance to use her phone. Yeah, and this is consistent with her. That is how she testified. A judgment of acquittal should be granted if the evidence, viewed in the light most favorable to the state, would not be sufficient to support a finding beyond a reasonable doubt. In the court's prior rulings regarding judgment of acquittal during the trial, the court found, so we're citing that the court made a finding. So The court found that the evidence was sufficient to support and prove all of the elements of first-degree premeditated murder and conspiracy to commit first-degree murder after the state rested and again after the defendant rested their case, allowing the case to go to the jury for deliberations. The jury found that the defendant was guilty of the lesser-included offense of manslaughter in count 1 and found the defendant not guilty in count 2. The reason or rationale behind the jury's verdict is completely unknown. Yep. And could be due to a number of reasons or rationale that lay outside the overall culpability of the defendant, including a negotiated compromise, partial jury nullification. Oh, man. I didn't know that they did this. This is true, right? This is true. But to see a prosecutor like, oh, jury nullification, we don't know why they did something. It's just interesting to see a prosecutor raise attention. It could have been because of that. Because if it was like a full guilty verdict on the top, they would say they looked at the merits of the case and the evidence, and that's the only thing, that's the only reason they came to the conclusion they came to. There's no such thing as a negotiated compromise or jury nullification. We get the full convictions that we're seeking. Lenity, mercy, or jury pardon, or some other unknown reason. Just because a jury returns a lesser-included verdict or a non-guilty verdict does not mean that there were not sufficient facts to support the charges. In Eaton v. State, the Florida Supreme Court held that 2 defendants tried jointly together on same evidence, in which one defendant was found guilty of first-degree murder and the other found guilty of only second-degree murder, could have been the result of a jury pardon, noting that the facts at trials were sufficient to sustain a conviction of premeditated murder against both defendants. In so holding, they recognized that different evidence may be admissible against different defendants, and that jury may result in conviction for lesser offense through the facts proved at trial would support a conviction of a greater offense. I don't know if that's really, like, that specifically related to what the defense is arguing here. Because the defense is arguing a little bit in the context of the dual jury instructions with the intent of an act that ultimately would end up causing the death, even if the intent wasn't to kill somebody, or the culpable negligence standard, right? And so their argument fits within that context of the failure of the jury instruction, and then they acquit on the conspiracy and come back on the second-degree manslaughter, where both instructions were given, and the defense asked for only one theory to be presented. And now we can't get into the jury's mind because they were given instructions on 2 different avenues. So I don't really see that this case being relevant where you have 2 different people and the jury considering the counts for each individual, 2 different co-defendants. They give another case here, it looks like. It says, further, the Florida Supreme Court reasoned that the jury may have extended to co-defendants a measure of mercy it chose to withhold from Eaton, the instigator and ultimate beneficiary of the escape plot. And then Maximo v. State, a trial court found ample evidence to support denying judgment of acquittal despite verdict, which could have been the result of lenity. The jury simply deciding to acquit on a charge, even though there was ample evidence to support it. And then we've got, in addition, the state relies upon these arguments in response to defendant's argument that the verdict is contrary to law or the weight of evidence. Wait a minute. So then they say the evidence presented at trial was sufficient to support first-degree premeditated murder, but the jury, after weighing all of the evidence, including the defendant's testimony, determined that the defendant was only guilty of manslaughter. So their entire argument about weight of evidence is just, we're adopting this bit about how somebody could come to a manslaughter through a theory of mercy. That doesn't, I don't feel like they address the weight of the evidence here in their response then. Because they kind of argue that it could have been for mercy and we'll never know. I don't really feel like they're addressing the argument raised about weight of evidence. But okay, they give that one sentence and just say there's no issue. Yeah, Mike Morrow, this is the exact type of word. It's a nice short word. Lenity, I don't know. It's got to be lenity, right? Leniency, lenity. I don't know. Small words sometimes beat me up because I want to say lenity. I don't know. It should be lenity. if it's leniency. I don't know. We've got defendant's motion for a new trial. In the defendant's motion for a new trial, the defendant argues that the court erred in various pretrial and trial rulings, that the court erred in excluding the defense witnesses, the court erred in allowing the admission of years-old text messages, the court erred in including culpable negligence theory of manslaughter instruction, the court erred in failing to give a special jury instructions to be included in the principal instruction, and the verdict was used against the weight of the evidence. In relevant part, Rule 3.600b requires a court to grant the new trial if substantial rights of the accused were prejudiced because 6, the court erred in the decision of any matter of law arising during the course of trial. 7, the court erroneously instructed the jury on a matter of law or refused to give a proper instruction requested by the defendant. Or 8, for any other cause not due to the defendant's own fault. The defendant did not receive a fair and impartial trial. So Rule 3.600A2 permits the defendant to seek a new trial on the grounds that the verdicts were contrary to the weight of the evidence. The trial court acts as a safety valve by granting a new trial, where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. However, the rulings claimed by the defendant were correct and lawful rulings. The defendant received a fair and impartial trial. Thus, the defendant is not entitled to a new trial. The state relies on its previous arguments regarding the court's pretrial and trial rulings with regard to the gang evidence and incidents of domestic violence. The court did not err in any decision or of any matter of law, nor can the defendant show any prejudice or bias. In addition, the defendant claims that Judge Sisco erred by excluding defense witness testimony related to domestic violence incidents. However, the record demonstrates that the court properly ruled with regard to defendant's witnesses. After defense brought up the defense witness Jewel Jordan and Jaquela Robinson in the trial, the court stated, "But they have no knowledge of her state of mind on the day of the murder. They have none. Zero. They don't even know what she was thinking. They don't know why she went with the defendant to Tampa. They don't know why she handed the phone to him there in the parking lot. They don't know why she was in the car with Isaiah Chance, allegedly following Julio Fulio. So it's irrelevant. It's irrelevant. And if you're not alleging duress, honestly, it makes it even more irrelevant." And defense counsel continues, "Well, Judge, it's not about whether we're alleging duress. The element for first-degree murder has to do with intent, so state of mind. So that has so many components to it other than duress. Like, it's not about duress, it's about intent. It's about state of mind. Those are two separate things. Yes, duress can be part of," and then the court responds, "Correct. And none of these witnesses can testify about her state of mind. None of them can. And yeah, well, they can only if it's relevant and it's not. So I'm going to abide by my previous ruling on this issue." The court's rulings regarding the defendant's witnesses were proper and correct. As to the years-old text messages between the defendant and her friend, Jewel Jordan, the defendant filed motion to exclude the text messages during the trial, calling them remote and irrelevant. The court properly ruled them as admissible and relevant evidence. So this is in relation to the he's ugly and need to die. The defendant was charged with committing the first-degree premeditated murder and conspiracy to commit the first-degree premeditated murder of Charles Jones, also known as Julio Fulio, a well-known rapper from Jacksonville, Florida. The defendant was charged as a principal along with 4 other co-defendants and lied about knowing anything about the victim or anything about the gang war in Jacksonville, or even knowing that her boyfriend went by the nickname Gutta when speaking to law enforcement detectives about this crime. See, this is their argumentative lens. Right? But part of me wonders if, like, they really don't get what Alicia could have been doing in that interview. She could have simply been asking, why are you calling him by his street name? Because her question was, why are you calling him that? It doesn't necessarily mean she's asking, why are you calling him that because I've never heard him called that before. It could be, why are you calling him that because you guys are, like, professionals? Like, shouldn't you just be calling him by his government name? And I wonder if that's something that, a thought that even could come across this prosecutor's mind, that different people speak differently with different meanings. The text, but she could still maintain her theory, don't get me wrong, about that's why she said it that way, is because she was lying and pretending not to know him. But I don't think I think you're missing contextual understanding if you think that's the only possible way somebody would say something like that. So the text messaging between the defendant and Jewel Jordan included messages about her knowledge of the gang war, her dislike of the victim, and incident involving when a friend of hers who was shot at Rains High School, an incident in the gang war. One of the messages stated, "Girl, I don't like Fulio, LMFAO, ugly AB. He need to die, and shit, that was my friend. Fuck that hoe shit, bitch. He shot me and my friend dead? Yeah, I'm pointing my outfit, who did it. I point out who did it." The court properly found that it is probative and it outweighs any potential prejudicial impact. See also Joel Jordan's testimony. The defendant has failed to demonstrate any error in the court's ruling. The defendant claims that the court should have not included culpable negligence theory to the manslaughter instruction. And I think this is the biggest issue. I think this should have gotten like 10 pages of argument. The defendant claims that the court should not have included culpable negligence theory to the manslaughter instruction. The court included the culpable negligence language in the manslaughter jury instruction over the defense attorney's objection and at request of the state. Manslaughter is a Category 1 lesser included offense of first-degree premeditated murder and was required to be given to the jury. There are 3 theories of manslaughter in Jury Instruction 7.7, which includes intentional act, procurement, and culpable negligence. The only theory of manslaughter that clearly did not apply in the case was procurement, which required the defendant to persuade, induce, prevail upon, or cause another person to do something. The standard manslaughter jury instruction, it's kind of weird that they'd argue that when they had the conspiracy against her. The standard manslaughter jury instruction allows the jury to find for a lesser offense based upon 2 different theories, whether the defendant intentionally committed some act that caused the death of a person or death was caused by the culpable negligence of the defendant. The manslaughter jury instruction was correctly included and read to the jury. There is no prejudice or bias to the defendant by including an appropriate Category 1 lesser included standard jury instruction. The defendant further claims that the court should have included special language into the principal instruction and deviated from the standard jury instruction 3.5a. The defendant specifically requested extraneous language that was not necessary. I mean, but if they supply, they're not addressing the case law. So in the defense motion, they gave the case where the language was lifted from. Why wouldn't you challenge and argue against that? Mere presence at the scene, including driving the perpetrator to and from the scene, is not sufficient to prove. Okay, so they're reading this language. This is the language being quoted. They want this mere presence at the scene instruction. The display of questionable behavior after the fact is not sufficient instruction. And knowledge of the crime after it was committed is not sufficient to prove a conscious intent of the crime. The court gave they did not include this. The defense wanted these, and none of the 3 were included. The court gave the standard jury instruction for principles and the standard instructions for both crimes and the lesser included crimes, which define all other crimes elements. The trial court giving the standard jury instruction on principles adequately explained defendant's theory that mere presence at the crime scene was insufficient to prove criminal complicity. At defendant's trial for the first-degree murder, where proposed jury instruction requested by the defendant that stated that the mere presence of the defendant at the scene of the crimes and knowledge that those crimes were being committed was not sufficient to establish that the defendant aided and abetted the criminal offenses charged, added nothing to the standard instruction. I think this is a problem to argue. Why would you argue this? Because this might be right in relation to second-degree murder. So what they're saying here is, well, the principal instruction spelled it all out. The principal instruction spells it all out. So yeah, they didn't get this mere presence at the scene, including driving the perpetrator to and from the scene, is not sufficient to prove the defendant intended to commit the crime. And remember, one of the ways you can get to manslaughter is intent to do something other than the homicide, the killing, right? So if the state is arguing here, oh, it's fine because the principal parts included all of that. The jury submitted a question. They had a jury question during deliberations where they asked the court if principal applied to second degree. So it seemed like the language, the conceptualization, the definition of principal, and any of the language around it might have been significant in their deliberations. So now if the state is arguing here that, well, wherever the principal theory would apply, and you could be a principal to second-degree murder, then maybe the mere presence also applies to second degree. But maybe since we're not going to apply, we're going to say that she's not guilty of that, even through a principal theory, we're going to move on to considering manslaughter. And while we're considering manslaughter, this principal thing's off the table. We're just looking at it like, are you dumb? How did you not know better? Like, maybe that's what we're looking at now. And then that mere presence language isn't there because they're not looking at the principal part. So maybe it would have been significant if we had this paragraph here. But the state's argument, I think this is a dumb argument. They're like, well, the presence theory, the presence wording was there in part in relation to the principal theory definition. I think this is a dumb argument for them to make, just saying. So, because it's saying that something that they considered where this presence language was included, they decided did not happen. And the judge declined including the presence language, the mere presence language, as part of the jury instructions that could have been considered for manslaughter. So I think that's an indication it could have been impactful and changed the outcome had that instruction been included as requested. So I don't know why they're arguing this, but they are. Maybe I'm not seeing it the way I'm supposed to see it. They say further, let's see. Standard jury instructions are presumed correct and are preferred over special instructions. And then they do give case law here for Peters, who cites Brown v. State, and Stevens v. State. Then they say in McGuire v. State, the court refused the defendant's request for special instructions. The mere presence at the scene of the crime or transporting someone from the scene was not sufficient to conclude that McGuire does not mean that the accused knew a crime was going to be committed and correctly gave the standard jury instruction of principles, which adequately and accurately explained the state law. I wonder what the charges in this case were, though. And what was he convicted of? Okay, it's just taking me to a generic opinion page on the Fifth Circuit, right? Okay, their opinion search is being funny. I'll look it up while we watch the hearing. Or find it on, like, Justia or something. Is this at Case Mine? So here's a major distinguishing factor. The first line from the opinion, Jeffrey McGuire appeals his convictions for first-degree murder. So it seems like what the jury found him on would have included the principal language as part of that specific count without getting into any lessers. I hope we see that counter argued on in the reply from the defense. I think, yeah, when we get down to manslaughter, if we're not considering the principal theory anymore, then we're not considering the mere presence language that's attached to the principal definition. And we don't have the separate inclusion of a standalone mere presence instruction. The defendant also argues that the trial court improperly denied the defendant's challenge for cause against a prospective juror and failed to provide the defendant with an additional peremptory strike. Again, the defendant just makes these assertions without providing any facts from the record to prove that the judge made prejudicial ruling or made a legal error in the decision. The only juror that the defendant refers to in the motion is juror number 6. And that's true, they don't go into the specifics. Well, didn't they say juror? They had to choose... They do say that they had to choose juror like 62 or something as well. So they do specify another number. The defendant requested a challenge for cause on juror number 6 based upon his legislative history, based off of bills that he supported, and based off of the fact that he said that his life, he can't get rid of his life experiences in the Senate and in the House, the legislature, We believe that there is reasonable doubt about whether he can be fair and impartial in this case. As from the transcript, the state responded, Judge, we object. He did say that he could be fair and that he could be objective. The court properly ruled and provided a well-thought-out legal decision supported by case law. Okay, so I'm going to cite Fleming v. State. Yet courts also recognize that it is impossible for an individual to ignore all of their previously held beliefs, and so even the formation of an opinion or impression regarding the guilt or innocence of the defendant shall not be sufficient ground for challenge to a juror, so long as the court determines that the juror can render an impartial verdict according to the evidence. The test for juror competency does not require an individual to lack feelings, opinions, or even preconceived notions about a case. Rather, the test is whether a juror can lay aside those feelings, opinions, and preconceived notions to render a verdict based solely on the law and the evidence presented. So, based upon that, I'm going to deny the challenge for cause as to juror number 6. Then the defendant posits that there were several other defense cause challenges that had merit, but fails to state specifically which ones. Again, the defendant fails to support their assertions with facts and evidence from the record. Based upon this unsupported claim by the defendant then claims that since they were unable to use cause challenges against juror number 6, that they were forced to use a peremptory challenge, and claims that they were all out of peremptory challenges with the court when the court got to juror number 6. Some of these words are tripping me up because they're like mixed up the way it's written. Further, the defendant claims that she will likely be able to show error in the jury selection process. The defendant has failed to demonstrate any errors made by the court during the jury selection process, and therefore the defendant's motion for a new trial should be denied. I don't really think that this was one of the stronger arguments. Again, I really think the jury instruction was the strongest one, and there were multiple layers to it, and it was kind of glossed over in this reply. It was not what the state spent most of its time and energy responding to. We've got, in conclusion, the state relies upon the entire record, including the transcripts of the proceedings for all pretrial motions and the complete trial transcript, to establish that the verdict in the case was supported by the facts and the evidence introduced during the defendant's jury trial. This hangs off. I do wish they did something like, here's like 3-4 things that establish how a reasonable juror could have gotten to this verdict. And I don't see the problem in just spelling out like 3-4 pieces of evidence that do that. I don't think it's a strong argument to just say it was because we say so. Therefore, the state, and maybe they'll expand on it at the hearing tomorrow. They'll give the specifics. I'm sure they will. Therefore, the state respectfully requests this court deny the defendant's motion to reconsider previous pretrial and trial rulings and second amended motion for judgment of acquittal notwithstanding the verdict, or motion for a new trial. And then they certify that a copy was sent over to opposing counsel. And then signed off on this was April 3rd. You got Susan Lopez and Michelle Doherty as a signatory. So, and then last up, this one's way shorter, is the final reply from the defense, and then we're going to watch that pretrial hearing there. How are you guys doing in the chat, you guys? Hey, everybody. Happy Mother's Day if you're celebrating. Kristen Vasquez in here, dropping not just 5, there's 2 in here, so 10 total. Shout out to Kristen. Let's show some love for Kristen in the chat. If you turn green, thank Kristen. Good to see you as always, Kristen. Thank you so much for the gifts. We've got Martina hanging out with us today. Thanks for being a member 21 months. Hope you're doing well. Says, free the principal. Not the principal, but the principal. Oh, man. Let's see. Yeah, see lots of love for Kristen here. Hey, Sirach. Hey, Keisha. Hey, Sharon. We've had Mike in here, but hey, Mike again. Yeah, so no sentencing so far. That's correct. It's still, if none of this is granted, right? If none of this relief is granted, sentencing will be set, will proceed. And I would imagine the defense would take it to the appeals court, right? Same arguments, similar arguments, maybe some tweaks and adjustments, but we'll see these issues come up again, filed as part of an appellate brief, I'm sure. So, but yeah, so far no sentencing, although we might find out tomorrow if we're going to set a date and move into that. All right, Mike, I won't pull you up on the screen. Well, I'll try not to. I'd be forgetting things 10 minutes after I say them. So I got Adventure Aaron in the building. Good to see you. Factual Lie made it back over to YouTube. Let's see. Oh, Kristen had a cat do a computer type out. Pashan says expensive cat. Oh, man. All right, so we've got this 11-pager here. This was filed on the 10th of April. And we're doing this deep dive. It's a nice refresher on what we're going to have on the table tomorrow, what we're going to see argued. And maybe we'll get more from the state on these jury instructions. I don't know. Maybe I'm like totally in left field thinking that was the issue that I would have wanted to address if I was responding to the initial motion. But I don't know. So we've got their reply to the state's response that we just read. I know what the state's response reads less like a legal brief and more like a closing argument to the jury that's already deliberated. Okay, so we're starting out the gate with a little bit of spice and sass. A verbatim recitation of trial testimony, pretrial rulings, and transcript excerpts that fill 22 pages while systemically avoiding the legal questions actually before this court. The state describes at length what Judge Sisco said and did. It offers no meaningful legal analysis of why those rulings survive scrutiny under the governing standards now that a disqualified judge's rulings are subject to reconsideration under 2.330J. And it never once mentions DeCastro v. State. Oh, yeah, didn't we say we were going to see if they mentioned this case at all? The controlling case that governs this court's analysis on the motion for a new trial. That omission is not oversight, it's a concession. DeCastro holds that when an appellate court finds a disqualification motion legally sufficient, as the Second District Court of Appeals did here on January 27, 2026, the erroneous denial of that motion is subject to harmless error review, and the burden falls on the state to demonstrate the error was harmless. The state never attempts to carry that burden. It cannot. Judge Sisco made multiple consequential rulings that shaped the outcome of this trial, and not one of them can be insulated from reconsideration by the volume of transcript the state pastes into its response. And if you missed the beginning of the stream, unless the state got permission to file like a SIR response in opposition to this reply, the arguments end here until the hearing or a decision, whichever the judge is going to do. And here they granted a hearing for this to be argued. So even though this was filed on February 10th, the reason we don't see the state filing another motion arguing again is because they're not supposed to, right? They got their response. The moving party has their first and final reply, and then it goes to the hearing. So just because the state hasn't said anything more, it's not because they're like, oh, well, we concede, we have nothing else to say. They could have put more in their response that we just read, though, or changed their focus and addressed these things then. But the reason we haven't seen anything is just because it's procedurally they're not supposed to keep filing and filing. Although we've seen some attorneys, some prosecutors that would do such a thing. Adrian Love. This court should grant Ms. Andrews a new trial. Let's see. Oh, wait, there was more. Judge Sisco made multiple consequential rulings that shaped the outcome of this trial, and not one of them can be insulated from reconsideration by the volume of transcript the state pastes into its response. We did read that. This court should grant Ms. Andrews a new trial. The Second District's recent decision in Penny v. State confirms that the mere presence principle, drawn from Staten v. State, is an active and enforceable limitation on principal liability in this district. One that a standard jury instruction does not, standing alone, adequately convey to the jury. So in Penny v. State, let's see, it's October 1st, 2025. So this came down the month that Alicia had her trial start and end. So, and it's the Second District Court of Appeals. That's the same district that has jurisdiction over this appeal should one be filed. And the holding, they reversed the conviction on principal liability, where evidence showed defendant was present at scene, but state failed to prove conscious intent that crime be committed, reaffirming that mere presence, including driving perpetrator to and from scene, is insufficient to establish principal liability. Just out of this, I want to see the mess, I want to see the arguments, but also because there's no opportunity really for the state to reply in writing. I imagine they're going to reply and have to argue this tomorrow, and I want to hear it. I really want to hear that. So, and I want to hear if this goes up to the appeals court. I want to hear how the Second District Court of Appeals weighs this argument and analyzes this argument in the context of this case. The culpable negligence manslaughter instruction, given over defense objection with zero evidentiary support, handed the jury a vehicle it never should have had. The exclusion of defense witnesses Jordan and Robinson, who had personal knowledge of the abuse they witnessed. So they're disputing the claim that... So the state said, we deposed these two witnesses. And, that's under oath testimony when you do a deposition. And they didn't witness anything. That's their representation of the depositions. Here, the defense is saying, I don't know how else to interpret this, but that the defense's position is that they did personally witness abuse. And then denied Ms. Andrews relevant evidence on the central factual dispute. And Juror 6, a former state legislator whose professional career was dedicated to enhanced criminal sentencing, who openly stated he could not set aside that legislative experience, cannot be rehabilitated by reciting the words, "I can be fair," in response to the court's questioning. We got Matarans v. State. Jurors' assurance of impartiality after expressing bias based on life experience are neither determinative nor definitive. Juror must be excused for cause. So then we've got Rimes v. State being cited here, 5th District Court. Leading questions by trial court and jurors' eventual agreement that he could be fair are insufficient to erase reasonable doubt created by earlier expressions of bias. And that's interesting that this court was like, oh, if it's a leading question. So if a judge says, "Can you be fair?" and someone's like, "Yeah," maybe that leading question and them just saying yes isn't enough to really make the determination and be sure that that's an honest answer. The state's response to each of these issues follows the same pattern. Recite what happened, assert the ruling was correct, cite to general authority about a trial court's broad discretion to manage its courtroom. That is not harmless error analysis. That is not engagement with the legal standards, and this court should treat it accordingly. Let's get into argument. So, we've got the state first. The state never addresses the controlling harmless error framework and has therefore conceded the central legal question. So, the Central District Court of Appeal did not merely agree that Ms. Andrews had a feeling about Judge Sisco. It found her motion to disqualify legally sufficient. A determination that the facts alleged would cause a reasonably prudent person a well-founded fear of not receiving a fair trial. That determination is law of this case. The state cannot relitigate it here by arguing again that every ruling Judge Sisco made was correct and appropriate. What the state can argue, and what it conspicuously fails to argue, so they don't even try, is that the erroneous denial of a legally sufficient disqualification motion was harmless. So we bring up DeCastro v. State again, which defense talked about in their motion, and it was absent from the state's response. Under DeCastro, that is the precise and analytical framework that governs this court's review. In DeCastro, the appellate court found reversible error where the trial judge, like Judge Sisco, erroneously denied a legally sufficient disqualification motion and subsequently made consequential rulings that could have altered the outcome of the trial. The court found that the state could not overcome harmless error analysis and ordered a new trial. The state's response does not cite DeCastro, it does not attempt a harmless error analysis, it does not explain how any single ruling, much less all of them cumulatively, was harmless beyond a reasonable doubt. The state's silence on the controlling case is not a gap to be filled at oral argument, it's a forfeiture. This court should treat it as such and proceed to the merits of Ms. Andrews' entitlement to relief. So obviously we have a hearing tomorrow. But yeah, we do have them say, look, all of this is just an attempt at a second bite of the apple. But we don't really have them make the argument that this wasn't harmless. And sure, for all the other issues that were raised where the Second District Court of Appeals has not weighed in, the Second District Court of Appeals only weighed in on this writ of prohibition that was filed in relation to Judge Sisco denying the motion to disqualify herself. So for the state to argue other issues like, oh, the ruling was correct, whatever, they could add in something like, and even if you find it to be an incorrect ruling, then we also would argue that it was harmless. It didn't impact the outcome of the trial. But when there is this finding, they should say that because the court has made this finding, they're above us. We're stuck with what they found. But it's harmless. It's harmless. And they don't put that little phrase in there. They don't make that argument. So next we have the denial of the special jury instructions requires a new trial, and the state's response does not engage with the governing standard. So we've got the state's entire response to the special jury instruction issue is this. The standard principle instruction was adequate, and Peters v. State said so in a similar case. That's the whole of it. The state does not apply the three-part test from Stevens v. State. It does not address Penny v. State, which is that newer case that they just mentioned, a case from this very district decided weeks before this trial that validates the precise language Ms. Andrews requested. And it does not explain how the standard instruction adequately covered a defense theory that the state spent 2 weeks attacking in trial. The Stevens test requires that a special instruction be granted when 1, the instruction is supported by the evidence, 2, the standard instruction does not adequately cover the theory of defense, and 3, the instruction is a correct statement of the law. And remember, they lifted it from the case law. All 3 prongs are satisfied here. First, the evidence supported the instruction. The state's own witnesses established that Ms. Andrews was present in the vehicle, was not identified as firing any weapon, and did not communicate with the co-defendants who were not her boyfriend. The state's theory of the case, that Ms. Andrews was a lookout and spotter, is the definition of mere presence. The instruction was not a legal abstraction, it was a direct response to the state's evidence. Second, the standard principle instruction does not cover this theory. This is what they touched on at the end of their reply. It tells the jury what a principle is. It does not tell the jury what a principle is not. Without the requested language, the jury had no instruction explaining that being in the car, driving to a location, or learning about a crime after the fact does not, standing alone, establish criminal intent. The 4th District held in Perkins v. State, so we have case law on this. This is 4th District, that failure to give a requested jury instruction on a key defense theory where the evidence supports it is reversible error. Okay, that's a bit more general. The 2nd District confirmed the same principle. Yeah, that's a bit more general than I expected. I thought they were going to have a case where something like this happened. Third, the instructions were a correct statement of law. They were drawn verbatim from binding case law. The state does not argue otherwise. The state's citation to Peters is not responsive. 403. Peters addressed a proposed instruction that added nothing to the standard charge in that case. Here, the requested language addressed a gap the standard instruction does not fill. The distinction between presence and participation, and that gap, was the central battleground of the trial. Judge Sisco denied the instruction without providing a legal basis. She remarked that if there were a conviction, the 2nd District would tell her otherwise. That's not a ruling, that's an abdication. The 2nd District should, and likely will, tell her otherwise. And this court should not wait for that result when it can grant the appropriate relief now. And this is kind of like, I feel like this is a bit of poking the bear beyond this specific case. Like, I hear all the time, like, the trial judges, when you put in these motions, it's almost procedural. They're going to get denied and they're going to kick the can down to the Court of Appeals because the trial judge doesn't want to, especially in a disqualification case. Think about Whitaker and Glanville in the YSL case. Judge Fernandez here, Kimberly Fernandez, took over for Michelle Sisco. They still work in the same court together. And I think, isn't Michelle Sisco like chief judge? Let me double check that. Maybe not. I feel like they said the word chief in one of these motions for her. Yeah, they say in the state's reply, it was the chief judge was ordered to appoint a successor judge to the case in response to the defendant's motion to disqualify and the writ of prohibition. So that's where I'm thinking of the word chief. So they're saying, like, look, don't kick the can down the road to the Court of Appeals. Just do it now. Why wait? And, you know, I think that's a sentiment that might go beyond just this case. Next, we have the culpable negligence manslaughter instruction gave the jury a verdict it should never have reached, and the verdict is against the weight of the evidence. The state argues that culpable negligence is a standard Category 1 lesser-included offense of first-degree murder, and therefore its inclusion was appropriate. That is true as a matter of taxonomy. It is irrelevant as a matter of evidence. A lesser-included offense instruction is only appropriate where there's evidence to support it. And here, there was none. Yeah, and the state didn't really make this argument. They did just say, like, hey, it can be, so there's no issue that it was. And they didn't address a specific objection to it that it's not supported by what's on the record here. The state's theory from indictment to closing argument was that Miss Andrews intentionally conspired in a premeditated murder. There was no theory of accident, no theory of recklessness, no evidence of negligent conduct that caused Charles Jones' death. The state put on 6 days of testimony to prove that Miss Andrews knew what was going to happen and chose to participate. That's the opposite of culpable negligence. And that's why I think if there is a new trial, it's just going to be interesting. I think it'll be the most interesting of these 3 trials. The jury's verdict reflects exactly what happens when a court gives an instruction that has no evidentiary foundation. The jury uses it to reach a compromise. And so this is seeming like, hey, the state just argued, hey, we have no idea. They could have just compromised. It could have been for mercy. Well, if the state's conceding that could have been a possibility, that's kind of helpful for an argument that the weight of the evidence isn't there, or that the evidence isn't sufficient at all to support the theory technically. So it looks like the defense is embracing that sentiment from the state's response. The jury acquitted Miss Andrews of first-degree murder, second-degree murder, and conspiracy, finding in effect that the state failed to prove she acted with criminal intent. Having made that finding, the jury should have acquitted entirely. Under Florida Rule of Criminal Procedure 3.608(2), this court acts as a safety valve. It may grant a new trial where the evidence is technically sufficient, but the weight of the evidence does not support the verdict. That standard is met here. The weight of the evidence, including the jury's own acquittal on every intentional offense, demonstrates that a manslaughter conviction premised on culpable negligence cannot stand. Next, we have the exclusion of defense witnesses Jordan and Robinson was an independent evidentiary error that the state mischaracterizes. Oh boy, here we go. Here we go. We've got... the state spends considerable space defending Judge Sisco's repeated explanations of why duress is not a defense to homicide in Florida. That argument misses the point. Deliberately, it appears. Oh boy. They said bow, 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 bow. Or wait, where is the, where is it? Oh, I don't have it saved here. I was going to play the juryback clip, but I played that from X. I don't have it uploaded to StreamYard. But I said, thinking they fired shots across the aisle here. They said they missed the point deliberately, it appears. The defense never sought a duress instruction. Defense counsel stated this explicitly on the record multiple times. Quote, I've never asked for a duress jury instruction. I do not intend to ask for a duress jury instruction. The state's persistent framing of the domestic violence evidence as a duress defense was a straw man at trial, and it remains one here. Joel Jordan and Jacayla Robinson were not offered to testify about Miss Andrews' state of mind. They were offered to testify about what they personally witnessed. So they're pushing back on this because the state is saying that based on the depositions they had with these individuals, their testimony must have been something that either directly stated or the state's inferring from that they didn't personally witness any abuse with like their own eyes. But this is the second time in this reply that the defense is like, that's not the case. Specific acts of physical violence committed by Isaiah Chance against Miss Andrews. That is fact testimony. It is admissible. It is relevant to the nature of the relationship the state placed at the center of its case. Having argued that Miss Andrews' participation in the murder plot was born entirely of her devotion to Chance, Jordan and Robinson's testimony would have rebutted the rosy relationship the state tried to impose on Miss Andrews and Chance. Judge Sisco collapsed the distinction between what a witness can establish, that the abuse occurred, and what only Miss Andrews could establish, her subjective state of mind on a given day. That's not the law. A witness may testify to facts within her personal knowledge, and they cite Florida Statute 90.604. The question of what inference the jury draws from those facts is for the jury. By excluding those witnesses entirely, the court denied the defense corroborating evidence on a factual dispute the state created, and denied Miss Andrews her constitutional right to present a complete defense. And that's, they're citing here Walker v. State, which was reversed. Oh, that's 1894. Holy moly. Oh, that's a long time ago. Reversal required where court excluded otherwise relevant witness testimony. Next, Judge Sisco's denial of the cause challenge against juror number 6 was error that resulted in concrete prejudice to Ms. Andrews. The defense focuses on the erroneous denial of the cause challenge for juror number 6 as the most prevalent, but the erroneous denial of the other cause challenges compounds the prejudice to Ms. Andrews. And the reason they say that is because we were out, I don't know if they had like 6 challenges, but if they used all of them, and they shouldn't have had to use it for one, and they only wanted to exclude one other juror, excluding, not letting them use the one for juror 6 means they couldn't do it for juror 62, a peremptory. So the denial of cause challenges to number 6 was an error, and that error prejudiced the defense because it, along with additional denied cause challenges, required the defense to use its limited peremptory strikes on someone who should have been stricken for cause. The state's response to the juror number 6 argument is, well, he said he could be fair, and the state relies on the same case mentioned by Judge Sisco, Fleming v. State, arguing that a juror's formation of an opinion does not automatically disqualify him. That's an incomplete statement of the law, and it ignores the prejudice prong entirely. Under Con v. State, I don't know why I said Con Nass, I'm just like adding a name to the caption. And it's interesting because I believe this was part of the defense's motion. So we could have tackled the case law, like it was provided, and we could have responded to it in the response. But under Con v. State, which established entitlement to a new trial based on denial of a cause challenge, requires showing both error and prejudice. So you've got to show both. The legal standard is whether any reasonable doubt exists to the juror's impartiality. Juror number 6 was a former state legislator who personally sponsored and championed sentencing enhancement legislation, built 40,000 more prison beds, sponsored an amendment to bring back chain gangs, acknowledged his passion for making criminals serve their time, acknowledged he sponsored bills to hasten the time from conviction to execution for death row inmates, and stated that he could not set aside his legislative experience. A juror whose professional life was dedicated to putting people in prison longer, in a case where a life sentence was a genuine possibility, presents more than a reasonable doubt as to impartiality. The standard instruction that he recites the words, "I can be fair," does not erase that record. Such assurances are neither determinative nor definitive, and that's Matarans v. State. Juror number 6's thoughts were so entrenched and potentially pervasive that Judge Sisco quarantined him from the rest of the jurors before the defense could inquire into his experience, so as not to taint the remaining jurors. Oh, well, this is a problem. Because what's the point of seating a jury pool? Jurors are allowed during deliberations to talk about their views of the evidence and, their personal experiences. But you don't decide a case with just one juror. You put them in a pool of room, and the jury is supposed to deliberate together and come to a unanimous verdict. So if you're so concerned at the jury selection stage that this juror's thoughts will taint the pool who could be seated, the worry that you'd have to start over with an entire veneer pool, bring in a whole new pool, I don't know if it was like 150 people or what, that were brought in to be, jury selection for this case. But you were so worried that you might have to start over if you continued to have his statements and answers said out loud in front of the other jurors. You don't think that's problematic? I didn't know this happened. This is kind of, this maybe, I see the concern just for like the professional history, but this is a whole nother layer if you ask me. I don't know. So they say regarding prejudice, because Ms. Andrews was forced to use a peremptory challenge to strike juror number 6, she exhausted her strikes and was compelled to accept juror number 62, a juror who affirmatively stated during voir dire that he could not understand rap lyrics. Rap music videos and rap lyrics were a central component of the state's gang war evidence. A juror who self-identifies as unable to process the meaning of that evidence is not a juror Ms. Andrews should have been forced to accept. That is the prejudice Conde requires. Conde, I don't know. Conde. The state repeatedly complains that the defense fails to support its factual assertions with record evidence. However, the state fails to acknowledge that when the defense filed its timely motion for reconsideration, due 30 days after the order granting the defense's writ of prohibition, the trial transcripts had not yet been transcribed. Oh, so we couldn't have done that. We couldn't have pointed to the record because we didn't have the transcript yet and we had to meet our deadline. The receipts have since come in, and undersigned counsel did in fact identify additional cause challenges that were denied, resulting in the wasted use of Ms. Andrews' limited peremptory strikes. So now we're going to include some parts of the transcript because they're now available. From Mr. McLyman, we've asked for other cause challenges that were denied. Had we not been denied those other cause challenges, we would have a peremptory strike to strike Mr. Baudoin. For example, they probably, I don't know. Are these jurors' names under seal? For example, the peremptory used on number 6 and the cause that was denied on 6, number 8, 42, 76, and 89. And that was a little bit that they cite here. For the reasons previously stated on the record, these additional cause challenge denials establish further precedence to Ms. Andrews. So they're saying we did raise this issue previously at the time. I think this goes to show it pushes back against the argument, oh, you never asked for reconsideration. You never disliked the judge's decision until it was verdict time. Well, here's one example where that's also the case. The motion to reconsider pretrial rulings is properly before this court to the extent those rulings affected the fairness of the trial. So I think this is the last part, you guys, of this motion. We've got, although Ms. Andrews believes Judge Sisco erred by allowing the jury to hear and see evidence of uncharged crimes, the Jacksonville gang wars, the music videos, etc., that is far from the core of Ms. Andrews' requests here. Ms. Andrews' brief includes 2 sentences about the irrelevant and prejudicial evidence Judge Sisco allowed into the trial. However, the state goes to considerable lengths through multiple pages to argue that this court should not reconsider Judge Sisco's pretrial rulings issued on December 19, 2024. To be clear, Ms. Andrews' request for the court to reconsider pretrial rulings pertains to the rulings that were also revisited during trial, such as the ruling to exclude witness testimony. So they're calling out the state for dedicating, I don't know, it was, 22 pages of a motion? And I feel like a good 15 of them were, lumped down to one day with a blanket claim that they never had a problem with them. But here they're like, well, they put all that focus on it, but we're asking for reconsideration on other issues that weren't all the way back 9 months before trial. But they didn't address those, really. They didn't flesh those out. And secondly, we also revisited, which is a request for reconsideration, maybe not through a formal motion titled Request for Reconsideration on XYZ issue, but it's not true that the defense never sought to challenge some of the judge's rulings ever until they filed this February 26 motion. So they say here, to be clear, Ms. Andrews' request for the court to consider pretrial rulings pertains to the rulings that were also revisited during trial, such as the ruling to exclude witness testimony. However, Florida Rule of General Practice and Judicial Administration does not restrict reconsideration to rulings made after the disqualification motion was filed. It permits a successor judge to reconsider prior rulings where those rulings are perceived to be tainted by prejudice, and the cumulative effect of all of Judge Sisco's rulings, viewed through the lens of her conduct during trial, is relevant to that inquiry. Conclusion, the state filed a 22-page response which largely avoids the pertinent questions before this court. I agree. The main issue here is that the Second District Court of Appeal found that disqualification motion legally sufficient. That's the DeCastro case. DeCastro makes clear that a new trial is required unless the state can demonstrate harmless error. So they have the burden. The state never tried. Judge Sisco improperly denied the defense's request for special jury instructions. The culpable negligence charge had no evidentiary foundation and should not have been given to the jury. Defense witnesses with personal, relevant knowledge were excluded. A structurally biased juror sat on the panel. These are not close calls dressed up as judgment calls. They're errors, individually reversible and cumulatively overwhelming. Wherefore, defendant Alicia Andrews respectfully requests this court grant her motion for a new trial, or in the alternative, enter a judgment of acquittal notwithstanding the verdict, and for such other and further relief as this court deems just and proper. So we've got Jeremy signing off on here. I think this is great advocacy. I really do. I think this is great advocacy. To Take care, Mike, pulling your picture up quick and putting it away because you don't like it up there. Thanks for hanging out with us. I'm excited to see the arguments tomorrow. I'm pretty much always in the camp that trial judges, if they can kick the can down the road to the appeals court. In Georgia, we've watched some Georgia cases where the judge is like, well, you're just going to take me across the street to the appeals court if I rule on this, aren't you? And, occasionally we get the trial judge to rule from the trial court with the expectation that the state will go take it to the appeals court. I think most of the time it's going to get kicked down the road. So I think tomorrow might be a preview of some of the arguments that this judge may or may not act on. I would think that she probably won't act on it. But we'll see a notice of appeal filed, and it will continue with the Second Court of Appeals. And I think this is great advocacy. I really do. It's the type of thing where if I was in this situation, right, remove myself from the facts of this case, I would feel like my attorneys were fighting for me. So I know they got a lot of criticism during the trial. I think they got a great outcome for their client with the manslaughter conviction, right? I'm sure a conviction at all must be disappointing. but compared to the theory of the case and what was presented and what could have been on the table as far as convictions and the sentencing that accompanied the convictions for which she was acquitted, the count she was acquitted of, I think that's a massive, massive victory compared to what the outcome could have been. And then they're still doing this advocacy here. And I just got to give them the applause because I really saw them get a lot of criticism during the trial and, mocked for trying to disqualify the judge, but then the Second District Court of Appeals disqualifies the judge. So, of course, maybe people make mistakes along the way. Maybe the Taz story and opening statements was a little bit of a rough way to start. Fine and dandy. Nobody's going to be perfect all the time. But I don't think anybody can say that this attorney team is not fighting for their client. So then we said, we're going to look back. This is August 13th. This is a bit of a pretrial hearing. And part of why I wanted to play this is, when we get into trial, sometimes it's either so far removed. This isn't so far in the past. This is only like 2 months before trial started. But sometimes the hearings happen like years before trial starts, or people just don't tune in until trial kicks off and they miss these things. So I feel like a lot of people just didn't see this hearing. I thought it could be cool to revisit for those that have not. And for those that have, it's a good refresher in light of, really, it's one of the issues the defense is raising, but it was a smaller issue. It's kind of like almost a byline in their initial motion, but it's what the state spent most of their time addressing in their response. So we're flashback to August 13th. I am going to put it on 1.25 because I do got to wrap this up around 3 my time because I got to get some work done, unfortunately. If you don't want to tune in for this hearing, though, just know we'll be live again tomorrow morning to watch the Alicia Andrews motion hearing. So hope to see you bright and early tomorrow if you don't want to stick around for this. And if you do, here we go.
Okay, very good. Okay, so we are ready to proceed forward with the pretrial conference. State, are you ready to try this case?
Yes, Your Honor, we are.
Defense, you ready to try the case?
Yes, Judge.
Okay, very good. You can remain seated when you're talking to me. You're fine. All right, so we've got a couple of motions that the state filed. I have not received any from the defense, so we will proceed forward on the motion shortly. I do just want to talk schedule first. We have 100 jurors for Monday morning.
Oh, we got our answer. That's the pool, 100.
And for the record, Mr. McLymont, I'm familiar with you. If you can tell me your co-counsel again, for the record.
Malcolm, for the record.
Mr. Malcolm?
Yes, Your Honor.
Okay, thank you so much. And for the state, we have is it Ismer?
Yes, Your Honor.
Harmon, and Ms. Doherty. Okay, very good.
Oh, I've been saying her name wrong.
So, Mr. Malcolm and Mr. McLymont, I don't know if you're familiar with courtroom 1. It is over in the civil complex, the George Edgecombe Courthouse, on the 6th floor. And when we're done...
Oh, no. If you just got here, this is... Yeah, let me put up a banner. We're rewatching a motion hearing from August of 2025 before Alicia Andrews' trial that addressed the issue of the admissibility of like the domestic violence, nature of relationship type testimony. So let me get a banner up.
Here, if you would like to go over and just
There's
take a look at it,
live hearing
so that would be
tomorrow,
fine, just so you
but
have
this
an
is
idea.
old.
We're going to pick the jury in that courtroom, but try the case in this courtroom. So we do have a seating chart. Have they been given a copy of the seating chart?
Yes.
Okay. So you can see on the seating chart, it'll be jurors 1 through 100. So you'll be able, when you go into that courtroom, you'll be able to take a look at the seating chart and get a better idea of what it actually looks like. So this is not a death penalty case, but due to the fact that there may be a number of individuals that know something about this case, I may do a similar process that I would do in a death penalty case, but I just wanted to speak with you all about it. So due to the fact that we'll have 100 juror slips or questionnaires for you all to review, Madam Clerk, what's the earliest do you think we'd be able to get those slips?
What time is it?
Well, I'll have the attorneys be there as soon as you tell me the slips would be available to review.
Probably like 8:45 is maybe the earliest, just because I'm actually like swearing.
Okay, okay. So I'm going to ask the attorneys to be at courtroom 1 at 8:30 in the morning. And once the panel of 100 is pulled, the clerk's office does have the ability to send the questionnaires over to the in-court clerk for them to be printed up before we even actually get all 100 people brought over to the courtroom. So what I may do is give you all some initial time to begin reviewing those slips. And then I may do what I would do in a death penalty case, where I do an initial voir dire of the panel with regards to any request for excusal due to scheduling conflicts and also knowledge of the case. And in a death penalty case, I normally do those on an individual basis, so we can see how many individuals we have that raise their hand as far as to one of those two questions. And then I can decide how I'm going to do it. But definitely.
Oh, also, some context that we probably wouldn't hear here because I think it came up after this hearing. I believe one of the prosecutors got sick. It was a she, so it was either Doherty, I think it was Doherty, or Ismer, who I keep calling Alicia Eismer. One of the prosecutors got sick, so trial was supposed to start earlier than October, but that's why it got pushed to October at some point after this hearing.
Any individuals that have knowledge of the case, that will be done on an individual voir dire basis. And then I'll make a decision with regards to individuals that are claiming hardship once they raise their hand, if I'm going to do that individually or just do it as part of the group. So related to that, I'm going to need a stipulated statement of fact from you all that you've worked on that I can read to the jury, and that way they can at least have enough facts so that way they can hopefully tell us yes or no, I think I know something about this case, or no, I don't. All right? So once I've done the individual voir dire regarding any knowledge of the case, and once I have questioned the jurors about if they've got a hardship request to be excused, then I would begin just my part of the initial voir dire. There's a certain spiel that I do, which takes a little bit of time, not too terribly long. So my point is, I think that will probably take up most of the morning. So whatever juror questionnaires you still need to review, you should be able to have sufficient time over the lunch break to finish your questionnaire review before I turn it over to you all. Just so you know that with regards to the voir dire I will do regarding hardship requests or knowledge of the case, I will do the initial inquiry of the potential juror. And then if you all have follow-up questions, and then I will give each the state and the defense a chance to do follow-up questions of that specific juror, but limited only to that issue, whether it's either knowledge of the case and or a hardship challenge. When we break for lunch, then I will ask you all if you agree to any of those individuals being struck for cause. At that point, if you all agree and I agree, then I'll go ahead and dismiss any people that are obviously going to be gone. If either side objects at that point and says, no, I don't agree, it's a cause challenge, I want to try to rehabilitate or I want to question further, then great, they stay on the panel and I don't strike them. I would only strike them if you all agreed and I agreed it was a cause challenge. Okay?
I don't care. There's a co-counsel in the waiting room.
Oh, that's a good question. Yes, thank you.
Thank you.
They gotta let someone in the Zoom or WebEx
Right,
or whatever they use.
Welcome. Let's see, Ms. White, let me see here. Hello, Ms. White. Good morning. I was just going over kind of the jury selection process, and your co-counsel will be able to relay to you what I said. All right.
No problem.
Okay, thank you. Okay, so any questions just on process for Monday morning?
Nothing from the defense.
Okay, all right, very good. Okay, so I would assume it will take the rest of Monday to pick the jury. Hopefully we can get it done by close of business Monday. And then we would be, assuming that's the case, we'll begin with opening statements on Tuesday and then calling of witnesses. Obviously, if we get bogged down in jury selection and we can't wrap up Monday, then whenever we wrap up Tuesday, you all should be prepared to do opening statements, and the state be prepared to call a witness, at least one or two. Just so defense knows, we work 9 to 5, okay? And when I tell you it's a 10-minute break, I mean it's a 10-minute break. And when I tell you it's a lunch hour recess, it's a lunch hour recess. So if a witness is on the stand and it's 5 o'clock and we can finish that witness, then we'll work past 5 o'clock to get the witness done. But I do try and be honest with the jurors about the time commitment, and so it is 9 to 5, but we do move. So I'm not one to linger when it comes to breaks. Anything else, just kind of procedure-wise? Any other questions you guys have about jury selection trial?
Judge, I know that we are scheduled for 2 weeks, and the majority of our witnesses, we have a lot of witnesses that we're making the travel arrangements.
All right, we're gonna skip some of the scheduling. It was cool to hear like they had a pool of 100 that they were using for selection. Everyone had 1 hour for opening. All right, there we go. Let's get into motions.
Let's go ahead and turn to the motions.
Judge, we have 2 in limine motions.
And I did review them, and they appear to be kind of fairly standard, so I don't know if there'll be any objection or not, but let's start with the state's motion in limine regarding asking the defendant, counsel for the defendant, to refrain from making any direct or indirect mention whatsoever at trial regarding self-serving hearsay statements of the defendant unless being offered as a confession or admission by a party opponent. Additionally, any self-serving hearsay statements made by the defendant to any other defense witnesses or co-defendant. All right, defendants, any objection to this motion?
No, Judge, I mean, if it's self-serving, we say under the law, we follow the law.
Okay. And with all of these, I'm going to grant the motion with the understanding that if something changes at trial, and if you all think, the defense thinks that we need to readdress that, you just have to bring it to my attention and let me know before you get into this kind of evidence. All right? So if things change, the door's always open to discuss it.
And just for the record, we're looking at the second motion in the
This one is titled State's Motion for Order in Limine, so I think this is probably the first one.
It is,
Oh,
yes.
like that was filed back in December?
That was filed on the 31st day of July.
Oh, I just have to remember.
All right.
The ground's right in the middle of the first one.
All right, next up is the state's second motion for order in limine. And this is a number of paragraphs. All of this stuff appears to be fairly standard case law. Is there any objection to paragraphs 1 through 5 of the state's second motion for in limine?
No objection to paragraph 1.
Okay,
No
granted.
objection to paragraph 2.
Granted.
I mean, no objection to paragraph 4.
Okay, granted.
Okay, well. Judge, can I see the motion you have before you?
Yes.
Because I'm looking at a motion that is, and maybe this was a mix-up on our part. You have one titled Second Motion
Yes,
for Order in Limine?
I do.
Okay, all right. All right, you probably have the correct one then. I'm looking at something I think was, and I will admit that a lot of this was cutting and pasting from prior motions on other cases.
Sure, here, just take a look at what I'm
Okay,
referring
thank you,
to.
Your Honor, I apologize.
And then make sure defense is looking at the same thing.
Okay, yeah, this is right. Yep, that's it. Thank you, Your Honor.
Okay. All right, so far defense stipulated to paragraphs 1, 2, 4, and then are you objecting to,
And 6 was also stipulated.
okay, that's granted?
I guess paragraph 5, I don't completely understand, and 3, I guess, also, I would object to that.
Okay, and Mr. Harmon, in paragraph 3, what is it you're getting at here?
Okay, so So in paragraph 3, what we're seeking to prohibit is if a witness has a prior felony conviction or a conviction for a crime involving dishonesty or moral turpitude, such as petty theft or worthless check or something like that, that the defense be prohibited from asking or inquiring about underlying facts of the case or the nature of the charge in that case.
Unless the witness testifies incorrectly.
Yes.
Okay.
Unless the door's open.
Right.
My understanding is that was more than 4. I'm not sure if 1 here are kind of.
Well, it is basically 4 is just we're seeking to have an understanding as to the appropriate way to impeach with a prior conviction or crime of dishonesty.
Yeah, so,
So if 3 is pretty much the same as 4, we have no objection. We don't intend to ask about, to impeach witnesses with underlying facts from the cases that they had.
okay. And then the only question I would have on paragraph 3, it does state that concerning the underlying facts and nature of any pending criminal charges.
Right.
'Cause
So
that's a different
It is.
analysis than,
So I think in the second sentence of that paragraph, the factual allegations, nature of the charges pending are irrelevant to alleged bias or motive. The state would have no objection to the defense asking about the offense level and the exposure to the witness, the possible sentencing exposure.
and,
If it's a first-degree felony, then you're looking at 30 years. Second-degree felony, 15 years. I think the case law that I cited supports the fact they cannot get into the nature of the case and then start trying the case, basically.
and would defense or even state be able to get into the jurisdiction?
I believe so, because it would go to the bias. They would have more possible motive to testify favorably for us if it's here in Hillsborough, so.
Okay, so Mr. McClimate, so you all in agreement that when it comes to the underlying facts of any prior conviction, that's not admissible unless somehow the door's open if the witness doesn't testify accurately. When it comes to pending criminal charges, if any witness has a pending criminal charge, you all would be able to discuss offense level, like what degree felony or misdemeanor, what the maximum penalty exposure would be, and the jurisdiction where those pending charges are.
So yeah, the only objection I would have is that it should be limited to just those 3 things. Right? And I'd imagine, now to explain a little bit, that one of the witnesses, Robert Howard, because he does have a pending case in state and federal court, I would imagine that maybe this is to limit any questions as to him. But he did take his deposition, I think, 2 days ago. He did testify that he is open for a cooperation agreement, and those questions should be fair game for his credibility.
I agree.
Okay, that's fine. So as to that witness.
So that's interesting of a little throw. Oh, sorry, I'm blocking the captions. Let me move myself. Sorry about that, guys. That's interesting to hear in the context. If you just watched the Folio 4 trial that ended last week, well, for the guilt phase, they fought against the idea of wanting any leniency. But here we found out because Alicia's team deposed in Florida, in criminal cases, we are very open to allowing defendants in criminal cases call witnesses and have them sit for depositions where they give under oath answers to questions before a trial starts. And you can use those statements to prepare for how you're going to question that witness at trial, decide your strategy around them, and confront them on what they may have said previously. So it's interesting to hear that in a deposition with Robert Howard, Alicia's team has him saying under oath that he was hoping for leniency.
You can get into the fact that he is specifically stated he's hoping to get some type of cooperation agreement. Okay?
And Harmon's
then
not
as a
opposed
result,
to
I
that.
don't know if he's been,
Let me give the props to Harmon here. Scott Harmon, the prosecutor, said he wasn't opposed to the defense being able to question Robert Howard on the stand about expectations of leniency.
okay? And then as a result, I don't know if he's been given one or not, but if he has not been given any type of assurance or agreement, the jury can hear that, or if he has been given some type of assurance or agreement, the jury
Yes.
can hear that.
Yep.
Okay?
Yes, Your Honor.
All right, so it sounds like after we've discussed it, everyone's in agreement, so that motion, paragraph 3 is granted, as we just discussed. Okay, so then 5, is that basically this similar issue?
Well, it's similar in that it would be asking a witness about misconduct or prior bad acts that are not convictions.
Okay. Any objection to that?
Only, obviously, the state opens the door because they have asked the court to allow them to get into the history of the violence between different gangs
Sure.
and neighborhoods. So to the extent that I'm cross-examining a witness about those things, then I think that is all fair game.
Yeah, I agree.
Yep.
So
No
it's-
objection to that,
it's-
Judge.
It's granted with the understanding that if the state has opened the door to a specific bad act or specific act of misconduct, then obviously the defense would be able to question the witness about it. Okay? Okay? All right, and then I think that takes care of that motion, right?
There's a paragraph 6, which I don't believe.
They said they agreed to.
They agreed to it, okay, good enough.
Okay, so, and next up will be state's motion in limine regarding prior incidents of domestic violence between the defendant and Isaiah Chance. And motion to strike defense witnesses Jewel Jordan and is it Kayla Robinson?
Yes, Your Honor.
Okay. And I have reviewed the motion, so I'm aware of the factual basis. And I guess my first question would be to the defense, do you oppose this motion?
I do.
Okay, so go ahead, Stoney.
Judge, we did take the depositions of both of these witnesses earlier this week, and it became clear that their testimony is solely based on, again, it's self-serving hearsay. They did not themselves witness any sort of domestic violence incidents between the defendant and a co-defendant, Isaiah Chance. All of the information that was the basis of their testimony was relayed to them by the defendant after these alleged incidents took place. There were some visual observations that they made, but Judge, all of this is not only is it with the exception of their observations, is again based on self-serving hearsay, which would be inadmissible, but rather, Judge, this has to go to relevancy. This is a case where the defendant and all of the co-defendants are charged with first-degree premeditated murder and conspiracy to commit first-degree premeditated murder, and any sort of facts or instances having to do with this defendant and the co-defendant regarding domestic violence simply is not relevant in this case. The only possible defense that could possibly go to is duress. And Florida, the law is clear. There is two Florida Supreme Court cases. There are district court cases that are on point that says in an intentional homicide, first-degree premeditated murder, we're not talking about felony murder here, duress is not a defense. So why any sort of prior domestic violence instance between this defendant and one of the co-defendants who she was dating at the time would have any bearing to any material fact in this case? It doesn't. So I don't see why they should be able to elicit. That would only serve to confuse the jury. It's highly prejudicial, and it has no bearing to any material fact at issue in this trial, Judge.
Okay, Mr. McLyman?
Judge, so the issue is relevancy, and according to the statute 94-1, any relevant evidence that taken to the fact, material fact more or less likely. In this case, the state is obviously charged first-degree premeditated murder. So state of mind is going to be relevant in this case. And state of mind is definitely relevant in first-degree murder cases. Case law that I'll cite, Gorganis versus State, 451, Southern 2nd, 817, at page 822. It's a Florida Supreme Court case from 1984, which states that to convict an individual of premeditated murder, the state must prove, among other things, a fully formed conscious purpose to kill, which exists in the mind of the perpetrator for a sufficient length of time to permit reflection, and in pursuance of which an act of killing ensues. Obviously, this element includes the requirement that the accused have specific intent to kill at the time of the offense. So when specific intent is used or is an element of the crime charge, the case goes on to say that evidence, and it says evidence of voluntary intoxication because this case is about voluntary intoxication, but then it says, or for that matter, evidence of any condition relating to an accused's ability to form a specific intent is relevant. And so we're arguing here that the state of mind comes in when the state argues that Alicia Andrews' motive and intent to kill was based off of this gang beef back and forth, and also when the state argues that there are actions that Alicia Andrews took that represent or can be interpreted as actions to prove intent or motive to conspire with her co-defendants or to kill Charles Jones. So to rebut that argument and that evidence, we should be allowed to put forth evidence of what Alicia's true motives and intent were. That's her state of mind again. That's why it's relevant. And then also there's other case law, Roundtree versus State 113. This is a Supreme Court of Florida case. So the citation is different because it's from 1934 of the state. 113, Florida 443 at page 447, and it's 152, Southern 20, comma 21. That case says it has never been held that the defendant's privilege of becoming a sworn witness in his own behalf, in this case in her own behalf, has deprived, although subject to cross-examination on his testimony, has deprived the defendant of his right to detail facts which tend to throw light on his own motives and individual intent in being found in a particular situation or in doing a particular act when such motive or intent has been put first, put in issue by the prosecution. All right, so it's clearly relevant. It's long-standing case law that state of mind is relevant in a first-degree murder case, and in this case where we have evidence that would show the jurors what Alicia Andrews' state of mind was when these actions were occurring, is clearly relevant and admissible.
Well, wouldn't her state of mind as being a victim of domestic violence, particularly a victim of domestic violence by Mr. Chance, co-defendant, wouldn't that only be relevant to a duress defense?
No, I mean, it could also be relevant to a duress defense, but it's relevant in this case to the intent element of the charge. It could also, I mean, if duress was a legitimate defense, if we could get a jury instruction to duress on this case, then yes, it would be relevant to duress and to intent. But it doesn't solely go to duress.
Okay. Okay, any rebuttal, Mr. Ording?
Judge, obviously we have to prove state of mind. That is relevant. But when we're talking about, this is not a self-defense case where she has killed her attacker. In that case, you clearly would be able to explore that. It would go to a potential defense. This is not a self-defense case. And so the only other fact that would, or defense that would go to would be duress, and they're not entitled to a duress defense. And so we're very concerned with any sort of confusing the jury and them being able to explore or elicit any sort of facts or statements about any concern that she may have for a co-defendant. And that's what that case law, that Florida State Supreme Court case law cites to. It doesn't matter how afraid or scared you may be of one of your co-defendants. In fact, that Cole case is a woman who was charged along with a male co-defendant of first-degree murder and conspiracy to commit first-degree murder. Duress is never going to be an excuse if you're fearful of your own life to take another's life. And so that is the point. The jury shouldn't be able to hear any sort of issues that she does have with a co-defendant, because that defense is not available to her for first-degree premeditated murder and conspiracy to commit first-degree premeditated murder.
And I agree with what the state is saying as it relates to a duress defense and a duress instruction. We're not asking for a duress instruction, and we're not putting this in for the purpose of proving a duress defense.
Well, then what in the world would it be relevant to? That's the thing I don't understand the relevancy then. Because if you're not arguing defense, what does it matter if her co-defendant committed domestic violence against her? So why is that relevant?
I'll proffer at least one fact in this case. So in this case, the state will put on evidence that Alicia Andrews gave Isaiah Chance, her cell phone, so that either he could conceal his identity or that she could help him commit the crime in this case. And the past incidents of domestic violence, I'll proffer to the court, is that situations where Alicia Andrews was forced to give her phone over to Isaiah Chance, was beat, was dragged, sometimes even sort of like kidnapped in his home for not giving up her phone and for texting other individuals on her phone, right? And so in this case, where the state is saying, hey, she gave up her phone willingly, she gave up her phone for the purpose of planning this or helping to plan this murder, it's not the case. Her intent for doing that, her motive for doing that is completely different, right? And it's the past, the domestic violence and the past facts that I just proffered to the court that would shed light on why she's in a position where she feels that she has to give up her phone or can't leave and turn around and go another way because she's been abused by this individual in the past. And likely, if she doesn't comply with what he's saying, the same thing could happen to her in this situation. So
wouldn't she have to testify for any of that to come in?
She would.
Okay, so here's what I'm gonna do. At this point, I'm gonna grant the motion without prejudice, okay? So, regards to the motion for order in limine, you all are not to get into any prior incidents of domestic violence between the defendant and as Isaiah Chance, her co-defendant. However, if it appears to you that you think it's not relevant, we just need to talk about it before you get into it. Okay? So I'm granting the motion without prejudice to review it. With regards to the motion to strike the defense witnesses, I'm going to reserve ruling on that. I'm not just going to strike them at this point, but again, before you were to call them as witnesses or even discuss what their testimony might be in front of the jury, you can't do that until you've gotten permission from me. However, I do think, do you have a defense witness list other than just these two witnesses?
We have a cell phone expert
Okay.
that we listed, and that's it.
That's fine, because when we're doing jury selection, I'm going to ask you to identify any potential witnesses. So go ahead and include the names of these two witnesses on your list, just to make sure that none of the jurors know any of your defense witnesses. But again, we're doing this with the understanding that they're not going to testify, and you're not going to discuss what their testimony would be unless you've asked me to revisit this and I have told you, yes, this is now admissible.
And I also want to add to my argument. The state, back in December, they filed a motion in limine to get into a bunch of evidence about different gang wars and beefs in Jacksonville, and they said that was relevant to prove motive and intent as to Alicia Andrews, who's not in a gang, who's not even affiliated with a gang, according to their own witnesses and their own detectives. And that was somehow relevant to Alicia's state of mind. Something that has nothing to do with her, really has something to do with her co-defendants, and somehow that is relevant to her state of mind. But here, the state is arguing that things that have actually happened to her and reasons as to why she may have been in the position that she was in are not relevant to her state of mind, but yet something that happened years prior, something that has nothing to do with her, is relevant. So, I mean, it seems unbalanced. If we're going to have a trial and there's going to be evidence put forth about all this stuff, and Alicia Andrews can't talk about why it is that she was in a position, she was in a car with an individual, why she was giving up her phone, why she was been outside of a club with an individual, why she didn't call the police and all these different things. If she can't talk about that, it just seems to me as to be unfair.
Well, and again, that's why I asked you about the only way this comes in is if she testifies. Now, if she decides to testify, then we will have another discussion about this. And by then, I will have heard all of the state's evidence, and then I'll be able to, again, consider whether or not any of this testimony would now be relevant, okay? So
I guess in jury selection, I don't want to step on any toes or do anything, incorrect in jury selection. So if I'm asking questions about any sort of domestic violence, I wouldn't want to draw an objection and then be shut down if it ultimately comes in.
well, Steve, would you object if the defense just generally talks about or asks the potential jurors, have you ever been a victim of domestic violence? Have you ever been accused of domestic violence?
Judge, I would be just for this very fact. We don't know if she's going to testify. And again, even if she should testify, it is not relevant. It doesn't, we would be arguing, again, and objecting to any questions posed to her regarding any instances regarding Isaiah Chance. I think the law is very clear.
I understand. I know you may disagree with me. I'm just saying, if, and there's a lot of ifs built in here, but you guys only get one chance to talk to this jury.
I know.
So I'm kind of layering one scenario on top of another. So I just want to make sure that both sides have the ability to be very thorough with any potential jury panel members. And I don't really see the prejudice to the state if just generally speaking, because you're going to be talking to these jurors about if they ever been a victim of a crime, have you ever been accused of a crime, and I don't think there's any prejudice to the state if you're allowed to more specifically get into, and just while we're discussing it, because this is a murder charge, it's a crime of violence, have any of you ever been accused of or have been a victim of domestic violence? I really don't see the prejudice to the state during jury selection.
Your Honor, if I could suggest if that inquiry is allowed, and I understand the court's ruling, that it not be stated to the jury that an issue in the case. or anything to
Correct.
that effect.
Correct. So,
I agree with that.
okay, that's fine.
Your Honor, your ruling concerning us either party getting into that issue that's been addressed in this motion. That obviously applies to opening statements.
That's what I was.
I just want to make sure we're all.
Yes, there's everything so far. If I've granted the motion in limine, it's not coming in at all, not in opening statements, not in any question of a witness, not jury selection other than what we've discussed here, the exceptions, unless you, outside of the presence of the jury, the defense has come and said, listen, we now think this is why it's relevant and we want to revisit it. Okay?
I mean, we would like to get into it also in our opening statement. I don't know if we.
I know, you would like to. I would like to be, 20 pounds lighter. However, that's not going to happen anytime soon. So I understand this is what you would like to do, but listen, if at some point this evidence becomes relevant, in your opinion, you can renew your motion and we'll discuss it. And then at the appropriate time, it would become, if I think it was admissible, and come in, but not at the beginning. Okay? All right.
And Judge, as far as the defendant's testimony and this issue, that would obviously be something that would be addressed in a proffer outside the presence of the jury. If the defense believes it's relevant, that they would present that to you outside the presence of the jury.
Yeah.
Initially.
Once the state's rested and the defendant is making a decision whether or not to testify, we will have this discussion again. Okay? Because then, like I said, I will have heard all the evidence, and I'll be in a better position to know what I think might be relevant or not. All right?
Just, I guess if there's any record that needs to be made, we object to the not being able to use it in open statement.
It's duly noted. Okay? All right. Okay, I think that's that motion, right?
It is, Your Honor. Judge, I have a matter I need to bring to the court. We deposed.
I want to make sure they don't come back.
Earlier, the cellular expert. That expert was listed, I believe, sometime in the last 2 weeks. Is that accurate, counsel?
It's Friday.
Friday before last, I believe, was listed by the defense. So I conducted a deposition of that witness on Monday. He was informally spoken to in March of this year, retained in early April, I believe he indicated, and has since then been working on mapping of timing advance information from cellular records of the defendant's phone and the co-defendant's phones. He's now working on those as we come close to
So his
trial.
opinion is evolving, or is it set?
He didn't really have opinions other than the mapping, and what I indicated to him was I would prefer to depose you after I received the maps before I question. I did get.
All right, so remember the issue here is that when they had this hearing, they expected that trial was going to kick off in the next week or two. They had to delay it because one of the prosecutors got sick. So his issue here is I did get to depose this expert witness, but it wasn't when he completed his work. So it's not a complete, my deposition wasn't the complete scope of what he might testify to. And we're short on time because we believe at the time of this hearing that trial's about to kick off. They address this. I just want to make sure they don't revisit. I think this is the guy that we saw at trial that came in and was like, hey, they didn't even go and try to request surveillance footage from the Players Club. And these phones were in these other areas for like 30 minutes that the detectives just didn't go and address. Then they have scheduling. Let's just see what this is to see if there's anything else about the domestic violence evidence ruling that's part of these motions for reconsideration that will be heard tomorrow.
Okay. Anything further?
Judge, the only thing else in the state is all offers of proffering the defendant are revoked. We don't anticipate engaging in any kind of plea negotiations from this point going forward with the defense.
Okay. Ms. Andrews, you understand the state is revoking any plea offers to you. Do you understand that?
Yes, ma'am.
Okay.
I think they
The only
offered
thing
her
I have is
18.
that, a state witness, Robert Howard,
Yes.
is in custody, and I'm not sure if the state has already had the transport or signed back here, brought here.
I think, let me look. There was a writ someone signed.
Yes, Judge, the arrangements have been made. He has formal federal
Yes.
charges. There was a issue where we were waiting for the federal judge to give the okay, and I talked to the federal prosecutor, and they had filed their formal motion to continue the sentencing. So I anticipate that we should be getting word soon from the federal authorities that he is going to be shipped in time for the trial.
All right, because they need to transport Robert Howard because, again, they thought the trial was happening. I'm curious about this part about the plea deal because it seems like the state having to announce that they were revoking any offers means that there were actually offers on the table. And there were rumors before trial started that I saw floating around that she could plead 18 years. She could take a plea and do 18 years or 85% of 18 years. And that would be it, likely in exchange for cooperation against the remaining 4 co-defendants. But then I believe the attorneys did an interview with I'm Not a Lawyer But with Mel, where I believe they said that there were no offers. And that also could have been at the point in time where they did the interview, because they did the interview right before the October trial started. There were no offers at that time. So kind of like a gray area, but it is interesting to hear the state say we're revoking any offers that were out there. They're no longer going to be on the table. That implies that there was an offer made. So I don't know the specifics, but it just made me think about hearing that right before the trial started, if you guys remember. Okay, so Mavka says there were rumors about Alicia and Scotty. Rumors of deals. How did it correct to that? I believe both are lies. Well, they're revoking an offer. Otherwise, they wouldn't have said that. But it might not have been for 18 years. We don't know the terms of it. So, but that was something that was debated. And there were rumors that the deal was specifically for 18 years. And that's not on the record here either. So, and it was revoked. This would have been August 13th. So, as of August 13th, anytime after that, if somebody was asked, you know, is there a deal she could take instead of just taking this to trial? The answer truthfully would have been no, anytime after August 13th. So, and then it looks like they just wrap up here.
And a writ was signed by Judge Leffler.
Okay, thank you.
Okay. Okay, anything further?
That's it.
All right, very good. So the attorneys need to be courtroom 1 at 8:30 in the morning, and then if you all want to walk over.
All right, yep, they're just doing scheduling. So that was a bit of the arguments where the judge ended up granting the state's motion, but without prejudice, where the issue could be re-raised by the defense if it came up during trial, but with stern warnings like you're not going to be able to, don't try to introduce this evidence, don't just have someone blurt it out. And then, of course, during trial, the issue was re-raised, and the decision, again, was repeated, as we read in this 22-pager, where we had the transcripts included. So, there we go. That was a bit of context behind that. I think that rounds us up for all of the motions, the arguments within this motion that are going to be argued tomorrow. So, again, this is still at the trial court level. It's a different judge because there was the disqualification of Michelle Sisco, so we're going to see Judge Kimberly Fernandez at work tomorrow. And this is not quite at the appeal stage, but again, if this is all denied and they proceed to sentencing, I don't see why we wouldn't see a notice of appeal filed. I would expect that there would be. So, and context from Adventure Aaron, always appreciate it, says, sometimes judges require the state to make an offer for a negotiated plea. Even if the offer is life, you can still take a plea after that. It's just non-negotiated. Yep, so just no deal. And that's why I like to use the word plea deal when I'm speaking about something that's offered, rather than just saying the word plea by itself. Because a plea can be changed, a plea can be entered whenever. A defendant could show up on like the 3rd day of trial and just be like, you know what, on my own, without state saying anything to me, I just want to change my plea to guilty. I want to get out of this trial. I'm done. I'm going to be convicted. I want to avoid the mess. It doesn't happen all that often, but it can. And that's not a plea deal. That's just a change of plea. So, and then, let's see. We've got Take It to Trial is going to be going live in about an hour. She's been, it looks like, rewatching, talking a bit about the motions battle and rewatching the relevant parts of the trial. She says it's part 2, so I caught a little bit of yesterday, and I think she went through like some of Alicia's testimony. And she was on the stand for a while, so I would guess that probably more Alicia's testimony she's going to replay over on Take It to Trial's channel. I call her Sweet Pea sometimes, that's why I'm saying she. And her whole community will be watching more stuff, getting ready for tomorrow's hearing, starting in about an hour. So that's 4 p.m. East Coast time. So this is going to redirect over there. And if you don't want to hang out for the hour but want to come back, just know that that's going to be going on if you're interested in following that more. And tomorrow we'll be back at 8:30 in the morning Eastern time. It's quite early. We're going to be watching the Alicia Andrews hearing to see these motions, arguments. And then for the Folio 4 who just had the guilty verdicts on Friday, their penalty phase, the sentencing phase, to decide whether or not the jury is going to recommend a death penalty or not. That's going to start off at 1 p.m. Eastern tomorrow. So there's that. There's that. Yes, I see some flowers in the chat. Anyone that's celebrating Mother's Day, happy Mother's Day to you if you're a mom. If you're going to go hang out with mom, grandma, whatever relative that's celebrating, enjoy your time with family. And sorry to take up some of your time on Mother's Day. I should have done this yesterday, but I didn't think to do it yesterday. And I was like, dang. Tomorrow's like a holiday and I forgot. So here we are today. So I hope you guys are all having a good one. Thank you guys for hanging out and sharing your thoughts. You know, this is not a place where we see 100% eye to eye on every single issue or every aspect of things. And it's always good to have the chat here to learn new stuff from each other. And then see if a random pool of 12 people were selected from this chat, what a mock jury deliberation might look like. I always think it's such a cool, it's a privilege to be able to have a live chat and see people react and share their thoughts in real time on how they receive and interpret information, what they do with it, and, you know, share your knowledge. Hey, did you hear them say this one thing? No, let me go back and listen to that. It's really, I love to learn, and it gives me joy that YouTube has this chat feature and you guys are here. So appreciate you guys. Have a great, great Sunday, whatever you do. Maybe see you over at Take It to Trial, and hopefully see you tomorrow morning bright and early. Bring some coffee. Take care, you guys.